Lord, under the scheme, they have to provide their Aadhaar card and other documents. They are not providing. So we are in touch. In fact, we are very proactively approaching them and requesting them that please provide so that we can give you the alternative accommodation.
No.
And all the alternative accommodation is available.
In the order that my condition, which I said, that the encroachers who are given, my lord, a better kind of a deal, in the sense, and lordships wanted me to put that particular policy on record, which I have put on record. I want to show to your lordships one thing, and my argument is very simple because, my lord, I must say that I argued all those matters for decades, my lord, and therefore I am aware of the development of law of rehabilitation.
No.
And my lord, we actually...
Listen to what we propose to do.
Yes, ma'am.
We will hear this matter at considerable length.
Not,
we
my lord,
will grant leave. And in the meantime, we will direct the state to continue to implement the scheme of rehabilitation, which they have already started. And according to them, 197 have been passed, where the
I have, my lord, some problem.
I have some problem.
I have some problem, my lord. I put it to ourselves.
You get the same benefit.
Lord, the question,
if you succeed, whatever more is entitlement, your entitlement.
No. Not entitlement, my lord. I am not talking
There
about
are
entitlement.
84 families in the...
Mister, just wait. I am not talking of entitlement. I am talking of the sensitivity which it requires. And sensitivity is, my lord, this, that people who are living inside, they were getting medical benefits, they were getting, my lord, there was a school, etc. There was an employment. They were getting only 450 rupees. Now the scheme which, my lord, they have mentioned, the High Court has mentioned, is that people will be provided flats. And I'll show to your lordships, my lord, what the direction which have been given. I'll come to the direction and show to your lordships whether it fulfills the requirement. What about their education? What about their medical needs? What about, my lord, the drinking water? What about so many other things which, my lord, which are available to them? Which the national policy, which, my lord, the new Land Acquisition Act provides RNR, which, my lord, oh, I'm so sorry.
Kindly see 28th February affidavit of the state on RNR policy, and we compared this. We pointed out, Lord.
Let me argue now. Which, my lord, which is provided, my lord, only 1 second, which is provided under, my lord.
Parties are at liberty to complete their pleadings and file additional documents in the meantime.
May I?
In the meantime, the state would continue to implement the prevailing scheme.
Yes, my lord.
Under which a large number of occupants have already been extended the benefits.
Yes.
And the remaining would also be entitled to the same benefits. If ultimately
there are 84 families which are not vacating out of 534, 84 have not vacated. They should vacate.
The appellants succeed, whatever further entitlement is due to them
nothing.
But those 84 must vacate. Otherwise,
well, Mr. Tiwari, I am here. No, even otherwise.
One is, my lord, rehabilitation, something which has to take place immediately. After so many years, my lord, it will have no value. That's number one. Number two is, my lord, if I go to the directions, because lordship says the directions will be implemented, kindly just look at, my lord, one thing. Only one point. Look at the directions which...
One of your SLPs has been dismissed.
Yes, my lord.
That was in Forest Dwell. My lord, they were claiming under the FRA. I am not on that. I came on the beginning itself, said I am not on that. My lord, the rehabilitation is on Article 21. It has to be immediate. It cannot be, my lord, delayed. I am not, my lord. My lord, may I, lordship, my
lord, as an interim order in any manner, and the directions of the High Court will be fully complied with by the state as
May I show only one?
Out
Yes,
of
my lord,
five.
my lord, there's
May I
only
show only
issue,
one
my
point,
lord.
my lord?
There's one issue.
I'll not
that
argue beyond
I
that.
don't
May I
know.
show one point to
So,
your lordship?
Gonzalez, will you allow
Only
me
one
to say
point.
something?
Submit something, my lord.
I'm
Learned
not
AG
able
wants to
to
submit.
outshout
One second,
the
Mr.
virtual court. My lord, there's one issue, my lord. Your lordship in the
That's a
colloquial,
disadvantage,
your
Mr.
lordship-
Advocate General, of appearing through video conferencing.
My apologies, my lord.
You should have
Last
taken a
few
flight
days
to
of-
Delhi. Why don't you come? You're sitting in Tamil Nadu and you want to be at
Lord,
par with Mr. Parikh and Mr. Tiwari.
I would love to come there and address your lordship, my lord, but last few days of the High Court, we closed next week, my lord, for the summer, which is why there's some pressure of work on me. Otherwise, I would have loved to be there for today, for the hearing. But I
yes,
just
what do you
wanted to
want to
say
say?
one thing, my lord.
Yes.
My lord, your lordship remembers, my lord, a couple of weeks back, your lordship's bench has passed a collateral order on the environment issue, where the
Correct.
Solicitor General appeared. Your lordship has directed us to cooperate with the central government and the Central Environment
CEC,
Agency.
not the government,
huh?
CEC.
Ensure protection of the tiger reserve as well as the forest.
Yes.
For that to happen, these persons have to vacate from that premises, my lord. Right now,
We have not- That's why we have.
That's why we are clarifying that we are not passing any interim
Yes, ma'am.
order, and
Yes.
the pendency of this appeal would not be interpreted in any
Grateful
manner
to your
to be
Lord,
an
I-
impediment in the
Grateful to your lordship.
implementation
Yes.
of your schemes and the High Court order.
But I said so
Much
that we
obliged.
will, because we are not in the way, my lord. There is no question. I said so in the beginning. Only one point, my lord, lordship, permit me only one point. Just look at 110.
All right, we'll look at 110
Yes.
for your satisfaction.
My lord, there are,
We have
yes,
to do
yes,
that.
my lord, kindly, my lord.
Yes, Mr. Parikh.
I'm grateful. There are 534 families. Now, lordship will find
Yes.
in para 1, the direction is about giving them 240 homes, my lord.
Yes.
240 para 2. 240 in Milord, Tamil Nadu Habitat Development at Papan Gulam. And then 150 apartments in Rediarpatti.
Rediarpatti and Tirunelveli.
Now 144 are left out. For them, the direction is in B.
Yes.
In order to provide housing for remaining homeless and resettled workers, the state government will also make sure that additional measures are done to construct similar set of homes. 144 persons, my lord. One can understand that if they are providing, they may provide probably in a week or 2 weeks, whatever. What about the 144 families where they will go? There should be some.
Under direction to provide it.
No, but then, my lord, it is. What has been mentioned will also make sure. Now the question is if there is a
We
time
have
bound.
said that they will comply with
No,
the
my lord,
directions of the High Court.
there is a time bound. There should be a time bound thing, my lord. Everything is essence. Time is, my lord,
All
rehabilitation.
right, next case.
Lordships are not directing that they should provide them in within a reasonable
They
time.
will definitely provide without that.
Yes,
If
Lord.
they don't provide and they throw you out,
Yeah.
come here.
No, my lord, how I can, because
You can
lordships
always
are,
come back to us. Yes,
no,
yes.
how can I?
No.
Deep burial sites, I don't want to.
Item
They will not
52.
do anything.
Yes.
Well, in this, there are
I
two
thought
matters.
lordships will hear me on rehabilitation in a detailed way, my lord,
We'll
but
hear
tonight
you
do
at
not.
Well, there are two matters.
Well,
The
in item
first
52,
matter,
I'm
in
seeking
item
for a
52,
Passover.
your lordship has already granted stay.
Seeking for a Passover, my lord.
May I just
I've
tell
been
your
led by
lordship?
the learned Solicitor General.
Where is the Solicitor General?
He's on his legs in another court. He'll be here in another
Well,
minute.
may I make a
Aye.
suggestion?
Call him immediately.
In item 52, there is already a stay minutes, and we'll be filing a reply. In item 52.1, which was mentioned last week, your lordship tagged it with this matter. Notice has not been issued. They may give us a copy. The matter is posted in the Honorable High Court on the 7th of March. Your lordship may keep it before that on the 6th. We'll file our response minutes. I'm carrying some photographs and documents.
Wait. Let the solicitor come.
In item 52, your lordship had, that is the case of that veranda in the High Court. Your lordship had asked me to assist. Now, in that case, what happened? There are these orders which I must point out.
You are with the Chandigarh administration or with the High Court?
I am with the person who says no tree will be cut and no green will be concreted. I am with that person. And fortunately for me, this time the administration is on the right side. And so we are here.
You are with the
But
administration, not with the High Court.
my lord, administration is saying,
I'll make my submission.
administration is saying,
You
now,
have to change the MIK.
High Court has said something. Please see.
Perceived bias.
Please see this order. No. This is only the truth, my lord. Otherwise, I am always fighting the administration for Chandigarh, my lord. Just please see this order.
You are
At
supporting the administration in a wrong case.
just please see this order, my lord. Construction of veranda in front of
Mr.
courtroom.
Gupta, you are very for the High Court.
I'm appearing for the High Court.
Please see this order.
For once, Mr. Gupta is on the right side.
All right. But still, I'll try to assist your lordships to reach the right conclusion.
Yes.
Now, this order was passed, my lord. What happened that after these two orders were passed by the High Court for veranda, the Bar Council of Punjab and Haryana moved an application for impletement. and they moved an application for recalling of these orders saying that
Really too much. Bar
let-
Council is not
no, just
not to interfere in
just
the
see what
decision of the High
the
Court.
just see what the
Yes,
court
serious reservations.
just see what the court says.
I see.
I'm not one way or the other, my lord. Your lordship may take any view. Just see, in this respect, it is informed petition for special leave is likely to come up before the apex court for hearing on 28 January. Learned counsel appearing for the newly impleaded respondent for that is Bar Association, not Bar Council, Bar Association of Punjab and Haryana, has made an application for recalling of the orders passed by this court containing direction for construction of veranda in front of courtroom 1, issue of contempt notice against chief engineer. Court is of the considered view the factum may be brought to the notice of the apex court which is seized of the matter. Only thereafter some decision can be taken by this court on the said application. So therefore, I'm bringing this to your lordship's notice, my lord. This is what the court had said, and that application remains pending.
May I just tell your lordship what this issue is, Malad?
Yes.
May I just hand over 2 photographs?
Please.
Mr. Courtmaster, please. And is it Malad's?
Mr. Patwaria would be having a first-hand information. He doesn't need that photograph.
But Malad, I'm handing over
I
copies
have
anyway.
lived all my life there, my
You
lord.
also
This,
lived
according
No, Malad, I've been here, Malad.
according to
I've been here assisting your lordship, but Malad.
according to me,
And if he doesn't mind, Malad, I'll make my submission on
this
this.
is not
Now, Malad,
necessary at all.
Malad, this first photograph
Yes.
is of court 1.
Yes.
First photograph is the outside of court 1. Your lordship will find there are lots of lawyers, etc., all over here. Now, just come straight away to the last picture, page 4. This is Malad's the picture of court 2 to 9.
Right.
Court 2 to 9. Now, your lordship sees Malad's court 2 to 9, which has the same facade, has a little covering, Malad's, which is there.
Yes, shelter.
Shelter.
Covered veranda.
Covered veranda, that's all. And this is there outside court 2 to 9. I have been there enough number of times to know.
When was this constructed?
This was constructed years ago.
It was constructed when the High Court was constructed. There was a proposal to.
If you don't mind, I'm
just
not.
1 minute. I'm
No,
asking.
it's not adversary. The question is put to me.
So this at that time there was a drawing. The Chief Justice of the time declined the drawing.
If I-
There is now no drawing as to how this is to happen. This is a heritage building
If
with
you-
a World Heritage status. So all that the administration is saying is, let us get approvals and we will do it. That's all.
I don't know if the administration is saying that. I'm just saying, Malad, in the first picture, the Honorable High Court has, Malad, noted that not only do the lawyers standing and waiting there have to face extreme vagaries of nature, of heat and rain, rainwater enters from the door also, Malad, if there's a strong breeze. And they just want a little covering there, like before court 2 to 9, which have absolutely the same facade. That's all it is.
Patwaria, we'll let you know now first-hand information. Rajasthan High Court new building, one of the former chief justices invited the lawyers to have a discussion on where the land should be selected. That was in 2003. Immediately protests erupted. Finally, we could locate a land. 2007, because of the resistance of the association split. 2007, there was a foundation ceremony in which Honorable CJI, Justice Balasubramanian was there. The lawyers showed him black flags. The project got delayed. Ultimately, it could be commenced in 2013. And finally, in 2019, we had a new building at the location which should have been approved right there in 2003. And after that building has been set up, the lawyers said that this should have happened 25 years ago. That is the result of the lawyers objecting.
So,
The
that is-
administration of the buildings is not the task of the
So
lawyers.
that is not the tradition of Punjab and Haryana High Court. That is not the tradition of our bar, and we don't oppose for the sake of opposing. But I'm
looking to the
But
situation. which
there is
privileged.
it's not a building. It's a heritage structure,
the Rajasthan
and
High Court
and
was-
therefore. So, my lord, let him file his counter. Let him file his counter, my lord. We will assist.
Let Mr. Mehta come, we will
Yes.
take a
Then,
call.
my lord, can I request for to be kept it on Friday or the next week?
My lord, it has come up late at night. I also would request, my lord, let it come up on a Friday or next.
First, let Mr. Mehta come
All
and
right,
address.
let him come.
If we are convinced, we will call upon the counter, and if we are not convinced, we will dispose of these matters today itself. Finished.
All right.
Let Mr. Mehta come.
I'm a Micus at 2 o'clock in a matter. Just kindly accommodate me for a bit.
No, as soon as Mr. Mehta is here, both of you are here, we'll take up the matter. You can coordinate with Mr. Mehta.
That's all right.
Yes.
So it's only this little covering here, just to let lawyers stand in
the-
shade, Malad.
The issue, my lord, in fact, I would also submit, my lord. Let it come up after a couple of days because I have not read the file. In fact, only in the morning I was told this
You are
matter has
here
come up.
only to assist the
That's right.
on the
That's right.
business of the
But
court.
I would, yes,
If
I
we
would.
require your assistance
All right.
further, we
All right.
will.
All right. All right.
Why should we seek an agenda?
All right. No problem. All right. All right. Harsh.
Picture can say 1,000 words, my lord. So more than the counter, the picture.
Before Mr. Patwalia comes back, she will. Otherwise, see, he is already turned.
The sequence is.
Sorry?
53 was for settlement.
We will take it up. Wait. 54.
55.
What is
My
55?
lord, this is an early hearing application. My lord, your lordship.
Early hearing application we will allow. What day do you want?
My lord, today onwards, any day that your lordship, that's convenient to your lordship.
You tell us.
This week, my lord, this Thursday or next Thursday.
It's a appeal.
Yes, my lord. Your lordship has granted leave and expedited the matter and directed the matter should be listed after 6 months. 6 months are over. It was now more than that. And my lord,
So we can have it on 1st May.
first May.
First
May.
IE for early hearing allowed. This is the appeal on 1st May.
Grateful.
So 53 call कर दिया settlement हो गया है दोनों part. Both sides are here.
Yes, please, ma'am.
Like hello for us.
We mentioned yesterday, my lord, in terms of the settlement.
In terms of settlement. Settlement has been placed on record
Please, page 3.
by an IA.
That's right, ma'am. This is a joint IA filed by both sides, ma'am.
Joint application.
Page 7 is in Hindi, ma'am. The settlement.
IA 74956. No.
And it's 62021.
62021.
Please, ma'am.
All right. Hi, that's also there. They uploaded a copy of the compromise agreement. So what order do you want today?
And it's page 3, my lords. We have proposed a draft order, subject to my lord's kind consideration that order may be passed. This, the disputed property was decided to be sold to 2 people, my lords, and we'll be sharing the proceeds.
Parties hearing have the media. Yes, sir. It's been uploaded.
We'll have a physical copy in case required.
Hey, share. Party has. Last but one thing. Parties herein have amicably agreed to settle all their disputes. Order pardon. Settle all their disputes and sell the suit property and divide equally the proceeds thereof. Thereafter, neither side is left with any claim towards the other, and all their disputes herein are over, and they shall remain bound with this settlement forever. Terms settlement take effect, so all parties in the agreement are necessarily sell property to she so and so. Whoever receives thereof, there remains no dispute pending. To say all this in the order.
Well, it's a
We will
difficulty.
say that as per the settlement, the parties shall abide by it. Finished. Decree be drawn accordingly. In terms of the settlement.
That would be
In terms of.
That will work for them.
Look here. IS 2021 of 2025 is a joint application filed by the parties under Article 142 of the Constitution of India, read with Order 23, Rule 3 CPC, for passing a consent decree in terms of the settlement agreement dated 20th December 2024.
Please.
Full stop. Having heard the council, we allow the IA and the suit shall stand decided in terms of the settlement. Decree be drawn accordingly, and the settlement agreement shall form part of the decree. Parties to abide by the same.
Grateful.
End of the matter. Yes.
Obliged.
It's been disposed of accordingly. Petition है appeal है क्या? Appeal.
My lord, this matter is related to the pensionary benefits and the other benefits of the petitioner.
One.
Yet,
Item number 1.
he had already served 32 years, but today morning, my lord, my friend has showed me some few documents which shows that some benefits have been given by the department. The document has not been given to me, even it's not a part of the counter
What
record.
do you want? You want time?
I want time, and if they pass the record, I will check it, my
The
lord.
circular on which you rely upon doesn't talk of pensionary benefits. It only talks of salary and arrears for the particular period. So
Particular,
how can you claim
partic-
pension under that circular?
my lord,
And
particular,
then your
they
suit
were,
was after how much delay?
my lord, there were two suits, my lord.
Yes.
That there is a recurring loss. So that delay does not apply. That I'll show you, my lords.
So come
with
to
the,
that circular straight away.
If they want to give you, let them give you. Why should we keep this matter pending unnecessarily?
my lord,
When we are convinced that the High Court
I'm-
order does not suffer from any adversity.
I am not aware about that, my lord.
Whatever it is.
I'll just verify
That has
that.
already
I'll
been
come
given.
back to that.
Huh?
That has already been given, my lord.
In terms of the circular,
No,
or even the pensionary benefits have been given.
The
no, my lord,
retirement
it
benefit.
was not
Retirement
given.
benefits have been given.
No, my lord, it was not
There
given.
are
Even
only
I'm not
two
getting
increments
pension.
which we stopped. He has challenged only by way of suit for declaration at that time only. And that were challenged under the rule only.
Because we are not
And-
inclined to interfere with the
My
interim
lord,
order.
I have served already 32 years. I'm not getting pension, my lord, after
They are
that.
not entitled to
Mil-
pension, you will not get it.
My lord, I am entitled. My lord, I'll show that, my lord. The judgment, even the charge order was set aside, and my suit was dismissed only on the ground of delay, and that delay does not apply to this because there's a
Tell us,
recurring
what,
cost.
all right, tell us under what provision were you entitled to receive pension?
My lord, I'll come on that point, my lord,
Yes.
because
Tell us, please. The matter is listed at serial number 1.
my lord,
Come to the order of the High Court straight away.
my lord, the High Court has only discussed that the suit was dismissed on the ground of delay, my lord.
You retired in 2003.
My lord,
When was the suit filed?
it's filed in 2005, my lord.
Yes.
So it's within limitation, my lord. And why, my lord? Because
What is the prayer in your suit? Let us see
my lord.
right away.
My lord, at page number,
Only for increment, that's all.
They have granted.
Where is the question of pension and anything?
my lord, it was,
there was-
my lord, in the suit I was requested, the order passed by the charge order was not, it's a void order. Therefore, in view of to set aside that order as well as for the pension.
punishment order stopping 2 increments was only challenged
Yes, sir.
in the suit.
That was the order passed in 1997.
97.
Yes, my lord.
And therefore, the suit was dismissed on the ground of delay.
Yes, more than 3 years after the expiry.
My lord,
Simple as that, nothing
my
more.
lord, just give me a today's 1 week, my lord. I'll
Why?
get, my lord, on all to verify all these things, my lord.
All right, dismiss. Next case.
My lord,
No.
my lord, there is a pensionary benefits also we
Very
have.
well. Next case.
The sole respondent has passed away in this matter. We have filed application to bring on record.
First, let us see what is there in your case.
Yes, sir.
Is there any merit in your petition or not?
Yes, my lords.
There is.
My lords, there is, but as per the procedure, we'll have to bring on record the LRs first. That is why
No,
we
you
have.
can dismiss it without bringing the LRs. Why do you need to wait for the LRs to dismiss
We
it?
are asking for pension, right?
No, my lords, we are not asking for. We are
Yes, you
appearing
are.
for the bank. The respondent was asking for the pension on the basis of a circular, which granted only revision in pay.
That's right. That's right. The circular is reproduced.
Yes, my lords.
Yes. That doesn't speak about the pension.
Pension.
You are appearing for?
My lord, I'm appearing on behalf of the respondent.
Respondent has passed away.
My
You
lord,
represent the heirs.
my lord, I represent the heirs.
Have you filed their wakalnama?
No, my lord.
Then you file the wakalnama, we'll allow the implement, the substitution. That's all that you want.
Yes, my lords. My lords, they were appearing last time also. They have filed
We have not filed the wakalatnama on behalf of the heirs.
Of the heirs.
for name of yes, my lords.
We have not filed the wakalatnama.
Yes, my lords.
Have you filed substitution application?
Yes, my lords. We have filed 4
इसको allow
applications.
कर दीजिए and grant a week's time to the respondent to file the wakalatnama on behalf of the legal aid.
I'll file.
List again on next Tuesday. Come ready with the matter.
And I am for the wife. STD has uploaded the statement of asset and liability, and my client also has sent me the affidavit. You can give me 2 days, I will upload it.
Very
2 days.
on the request of counsel for the petitioner list after
After 1 week.
after a week. Next.
In item 4 mallards, I am for the petition mallards. I am for here for the very limited purpose mallards. Mallards, the observation made by the Lenny Singhal in the writ petition mallards. I am just only for those observations mallards, because mallards in counter affidavit they have already admitted, respondent has already admitted that the closure report has already been filed in the criminal case mallards. In respect of mallards, just kindly see the page number 74 mallards. It's a single judge order mallards. Page number 70, para 50 mallards. In respect of criminal FIRs mallards, some observation has been made in the FIR in the order mallards. The only those observations. Para 50 mallards.
1 minute. Page
70, para 50 mallards. CWP order mallards.
Page 70, yes.
70, para 50 mallards.
Huh?
Mallards, the surprisingly not only the respondent has given the additional charge of the said post respective of the specific bar as provided in the clause 1 of so and so, but the respondent was filing misleading and vague returns. Right, this is clear that respondent was not admitted to be given the current charge of the post subdivision Morena. Instead, he was given the said charge or so and so OIC. As stand has also taken by the respondent number 124 in their return regarding the local posting officer. Therefore, this court thinks appropriate to consider the caution also. It made clear that this caution is not directly involved in the present case, but it is cropped up because the specific stand taken by the respondent number 4. Well, respondent number 124 and has taken a stand that some FIR has been filed against me, my lords. This is
respondent number 5.
My lords, before the Honorable High Court, I was respondent number 5, my lords. In particular case, my lords, the closure report has already been filed. Just kindly see the counter affidavit.
At that point of time, it was pending.
At that time, it was pending, my lords, but at present, my lords, in the future, my lords, in future, it may prejudice the rights of the petitioner, my lords. Just kindly observe that, my lords.
Dismissed. Next.
My lords, just kindly given this observation, my lords, not prejudice the future of the future prospect, my lords, of the petitioner, my lords.
Obviously, it will not have.
My lords, just kindly, just single line, my lords.
Next case.
Much of it. My lords, dismiss as infructuous, my lords.
Dismiss as infructuous, all right.
Much of it.
Very good. Counsel for the petitioner said that this petition has been rendered infructuous. Also, it is accordingly dismissed. Next.
In this matter, but previous order was respect to mediation, but that has failed, my lords. The issue is, my lords, the High Court had granted divorce to the respondent on the ground of irretrievable breakdown of the marriage, my lords. But that power is not available to the High Court, my lords.
That's right.
That is my first point. Another point is, my lords, in maintenance petition, which is 5.1, my lords.
Now,
there
is decree under 142. Then what happens?
Well, there is a ground. Well, there is no cruelty. First, they have filed the divorce petition.
Since how long they are living separately?
More than 18 years.
Well, 2005 marriage was there, and 6 I think. My lords.
Separately.
Yes.
My lords. What happened, my lords? In maintenance petition, what happened?
Client is an engineer. He's a doctor.
No, my lords. He is not an engineer, my lords.
She's a double graduate, my lords. I am a doctor. I am a doctor. I am a dentist.
In their petition, itself, they are saying that she is a housewife.
Okay.
Divorce petition, they are saying, and the petition filed by their parents, or against they are saying occupation is a housewife. They know that she is not working.
Wait.
Another point is, there is
now
more
the
than.
Court did not grant any alimony.
Alimony was in maintenance petition. It is 18,000 per month.
Alimony was not granted.
No, my lord. Okay. And my lord, further, my lord, whatever.
Children out of the marriage?
No, ma'am.
No children.
No issues.
No issues.
No issues. But what I am submitting, my lord, in maintenance petition, whatever maintenance is there, my lord, they have also filed SLP. We also filed. Our SLP is pending, my lord. Their SLP has been dismissed. And they are, even thereafter, they are not making any payment. There is pendency of an execution petition against that, and which is more than 26 lakh.
What is the maintenance awarded?
18,000.
18,000.
But even that they are not.
You have fight for enhancement of that.
Yes, my lord. But their SLP has been dismissed, my lord, and still they are not paying.
Answer the question, now. Why are you continuing on and on? So your SLP is pending for enhancement.
My lord.
It is not listed today.
It is still
5.1 is there.
Yes, my lord.
And this is the petition against the grant of divorce.
Yes,
5.
Yes,
all right. Yes.
My lords, if I could only be given a minute, my lords. 18,000 is the amount that has been directed by the Honorable High Court, enhancing it from 6,000, as was ordered by the learned trial court. Now, my lords, 18,000 is from the filing of the petition. That would approximately amount to about 135 months. And my lords, as per my calculations, it will be somewhere around 25 lakhs or 24 lakhs 30,000. My lords, I have deposited about half of this amount before the learned trial court, about 12 odd lakhs. On the previous occasion, my lords had graciously referred the matter to the mediator. And my lords, in the order, my lords had specifically mentioned for a mediated settlement. My lords, and I very humbly submit, I have a favorable order, I have a decree for divorce in my favor. However, without prejudice and without raising any aspect, my learned friend said that it was granted on the ground of irretrievable breakdown. I very humbly denied that. There were also instances of cruelty. With or without that, my lords, I am completely covered by my lords' judgment in Shilpa versus Varun. My lords, more than 18 years we are living separately, no children out of the marriage. My lords, the marriage is dead for all purposes. I again very humbly state so. My lords, my limited concern, my limited prayer is to dissolve the marriage under 142. Insofar as the aspect of an alimony is concerned, it is 18,000 in perpetuity. So I am to pay 18,000 per month, my lords, till infinite period of time, if I may say so. My lords, regarding that, if the parties can arrive, or by way of a direction of my lords, if there can be a permanent amount, because that is all that in my humble submission remains. Insofar as an aspect of cohabitation is concerned, my lords, my instructions, needless to say, are that I cannot. It was me who preferred my lords, a petition for divorce.
Not only him, he filed injunction petition, his parents filed injunction petition. They does not want her to come and then say ki marriage is dead because they are not allowing her to come.
That was already allowed by the Honorable.
Then saying that she is not coming to me.
I have that even in my favor. Vis-a-vis
the 9% was allowed.
All right. Now, you have an offer in mind?
My lords, I do. I have an offer, my lords. I have been informed by my clients.
What is that?
My lords, up until now, about 12 to 13 lakhs have been paid, my lords. I have spoken to my clients till about 2021. However, if, my lords, there is a figure that can come from my learned friend, I have no difficulty convincing my clients vis-a-vis that. My lords, in their grounds, they have asked for an enhancement to the extent of 45,000. That is there. My lords, if a calculation is to be done with respect to this, right from the time of them filing a petition, it would be about 60 odd lakhs right now, my lords.
And what is the age of the parties?
My lords, I'm 58. I'm 58. 58.
And
58,
she will also be 55.
She should be like
around
that, my lords.
Of assets and income or something like that?
My lords, no. My ITRs were filed. That has been noted by the Honorable High Court as well. My income was stated. Now, my lords, my learned friend says that these are self-serving documents and the fact that you deliberately are showcasing lesser income than what you have. However, what is on record is on record, my lords. I had preferred my ITRs. Vis-a-vis ITRs, they are not before my lords. I haven't been able to prefer a reply to the criminal SLP, my lords. Against the civil SLP, I preferred my reply. Subsequent to that, it was referred to the mediator. If my lords are hearing it on merits, finally,
Have you remarried?
Please, my lords.
Have you remarried?
No, my lords. I haven't remarried. I could have only after this order, my lords, granting me divorce, but I haven't. My humble submission, my lords, it would be misery even upon my lords, the respondent's client. I have nothing further to say to this because the marriage is dead, my lords, for all purpose. $50, my lords.
50. Which will take care of the areas and everything.
Lords, could I be given some time to confer with my clients regarding this? If it could be after a week or 2 weeks, and if I can convince my clients regarding
Speak to him on phone right away. How do you want to keep pending?
My lords, he may not be in a position to answer right away because my humble submission, my lords.
Surgery. Then?
My lords, it is more than the reach that he can offer right now. Only after a week, my lords, I not seek a time.
If we either reverse the decree or we enhance the maintenance, both will be more costly to him.
No, I fairly state.
So then always
An aspect that I have already informed. Could it kindly be next week, my lords? It will give me better time to convince my clients. That's all that I'm saying. My lords, I'm not negotiating with my lords on this.
Having heard and counsel of the parties, a figure of 50 lakhs as permanent alimony has been indicated. Counsel for the respondent husband. There's also the counsel for petitioner wife. May obtain instructions. List again next Tuesday.
Wait. I'm so deeply.
My lord, so today I will take first step, my lord.
Today you take rest.
No, first step, my lord. Because the last week we were some busy with some other work. By mistake, we didn't take.
Service need.
Item 6.
Yeah, 6 million.
Rest of the time ले लीजिए.
Thank you. What do you mean?
My lord, I beg to appear on the petitioner, my lord. She's a lady, my lord. We have filed our assets, my lord.
I have
Affidavit of assets and been filed, my lord. Parties are here, my lord.
Filed my assets also, my
Yes,
lord.
both parties are filed.
Both parties are here, my lord.
My lord, both parties are here, my lord. But, my lord, can I read the affidavit, my lord, filed by me, my lord? Because I am an advocate. I am getting, my lord, I am with a senior, my lord. He is paying her, my lord, 4,000 rupees, my lord.
You are the husband?
Yeah, I am for the wife.
For the husband, my lord.
I am for the wife. He is for the husband, my lord.
You are an advocate?
Yes, my lord. She's an advocate.
My lord,
My lord,
you are also an advocate?
He's at plus two pass, my lord. He's working in marketing, my lord. He was diagnosed with tuberculosis, my lord, so couldn't work for last 1.5 years, my lord. Now he started working again, my lord. Filed my affidavit, my lord.
My lord, he has filed an affidavit that he is the marketing managing in a company which is owned by the mother, my lord. It's owned by the mother, my lord. And he is getting a salary of 35,000, my lord. There is an arrears of 13 lakhs, my lord. Originally, my lord, in maintenance, my lord, 6,000 was granted, my lord. Then, my lord, final
Now,
order.
the trial court and the high court both have.
It's a reversal, my lord.
Oh, yes, my lord. My lord, this is the matter, my lord, where the, my lord, if on merits, my lord.
Trial court dismissed my petition, my lord. High court,
High court, my lord, allowed, my lord. On the ground, my lord, there are some cases, criminal cases filed, my lord. That's a cruelty, my lord. It's ipso facto, my lord. That's the ground for, my lord, divorce under Special Marriage Act, my lord. Lord, there are judgments, my lord, to show, my lord, no. If a criminal case is being filed by a lady, my lord, husband can't come tomorrow to the court and tell that, my lord, he has filed a false criminal case against me. That's why ground for the divorce, my lord. I have two judgments, my lord, to show that on merits, my lord. But, my lord, be as it may be, my lord. He says, my lord, I am.
According to you, there are chances of joining together?
No, my lord.
No, my lord. No. He is married. He is married, my lord, subsequently during pendency of the stay granted by this honorable court. But there is a contempt petition also, my lord. My lord, he has a son also, my lord, which we don't know when he was born, my lord. But ultimately, my lord, I'll demonstrate before this honorable court, my lord, during pendency of the stay, my lord, this is a gross contempt by, my lord, committed by this person, my lord. But my lord, now he has come with the facts, my lord, gross, my lord. There's a
out of the marriage, there are no children.
No, my lord. First marriage, not with.
They're staying separately since 2015, man.
My lord, that's my lord. He says, my lord, I am working in a company, my lord, which is a Ludhiana, my lord, and that is called Trust.Menos. Trust.Menos. He's a sales executive in that, marketing manager, and he's getting salary of 35,000. My lord, see, my lord, the latest, my lord. We got in Google, my lord, and it says, my lord, he is a CEO of company, my lord. There is Sony, my lord. He is the CEO of the company, my lord. That company is being owned. There are two companies, my lord. Telecom? SL.NO. She has two companies, my lord. The family owns two companies, my lord. I have filed it earlier also. One is Trasmos. It's a company owned by the family. Mother is an. But here, my lord, he says in an affidavit, my lord, in the sets, my lord, that I am the marketing manager, my lord. I am getting 35,000. My lord, we could get, my lord, on Google, my lord. He is the company CEO, my lord. There is Sony, my lord. And, my lord, another company, my lord,
What is the salary?
My lord, he says 35,000, my lord. High Court. My lord, he says 35,000 per month. I am getting from the company, my lord, which is owned by his mother and other partners, my lord.
CEO don't get 35,000.
I don't know, my lord. He has to make his, my lord. He has to make his, my lord, submissions clear, my lord, and my lord, we see, please.
All right, keep it.
I got it today, my lord, my client.
Now you want to settle it finally?
I want to settle it.
How much do you want to? What is your offer?
My lords, in fact, my lords, all the interim maintenance, my lords, is up to date, my lords.
Okay.
On February,
How much
my
is
lords,
the
maintenance
you are paying?
6,000 rupees I had been paying, my lords.
They are also, my lord, areas, my lord. And now, my lord, 25.
He says it's up to date.
No, my lord. I filed an affidavit, my lord. In areas, my lord.
Let me complete, my lords.
Yes, complete.
My lords,
Don't make a wrong statement.
February, my lords, the final maintenance has been awarded of 25,000, my lords, which I have challenged in High Court, my lords. Notice has been issued in that one.
That is pending.
That is pending, my lords.
That idea is come
After
to
that,
30 lakhs, my lord.
I'm
sorry.
After that, there will be areas, man. I have not paid according to 25,000. I have paid according to 6,000. That was the interim maintenance, man. Because I have asked the respondent hearing, my lord. Because of his financial health presently, man. He was saying 10 lakh rupees, my lord. So I said that cannot be a reasonable amount for me to also take to the court, my lord. He said that I can pay 15 lakh rupees, my lord. Ask them, my lord. Then, my lord, I can convince him, my lord. That's why I asked him.
My lord, in trial court, my lord, they weighed 25,000, my lord, 25 lakhs, my lord. Excluding 13, my lord. If the income is 13, my lord, I had asked my client, my lord. I'm not a client, my lord. She's not a client. She's an advocate. It's pro bono.
Yes.
It's completely pro bono. He says 50, my lord. Because 50 including, my lord, 13 areas, my lord, is rent, as, my lord, maintenance charges.
30 or 13?
30, my lord. Please.
13 areas.
13 areas, my lord. And, my lord, their turnover in that company is 14 lakhs to 1.5 crores, my lord, per annum, my lord. That's the, my lord, that's the trust cost, where he's the CEO, my lord. And he says, I'm the marketing manager. There are two companies, there are two houses, they have, my lord, cars, they well off, my lord. They well off.
He's not in a position to pay 35 dollars. He was. I have placed on records his medical record.
Make borrow steel, do something and get the project.
35 he will not be able to pay, my lord.
So let them continue to pay maintenance at the rate of 25,000 for lifelong. Yes. And then she'll seek enhancement also. That will be
She
much
says
more
40, my lord.
expensive.
She says 40.
All right, we will decide ultimately.
Yeah. I leave to lords. You will work as an advocate.
Yes.
I told him you will work as an advocate, my lord.
Yes.
In line.
My lord is saying that at maximum he can do 20, my lord. That is also by back boring steel, my lord. That
20 plus areas, it will come to 35. That's how we had also calculated.
My lord, 20 in total, my lord.
No, not 20 in total.
My lord may.
All right.
Because my lord, he's here, my lord. Let him make a statement. I cannot make a statement on his behalf, my lord. He has to pay, my lord.
No, the statement, we would direct him, he has to pay, it's finished.
My lord, may permit me one thing, my lord.
Don't want his consent, we are only putting that figure to him.
Consider, my lord, decreasing it, my lord, because he's actually, my lord, not in a position. My lord, the family is married or remarried also, my lord. You have to take that care of that family also.
Yes.
I told my lord, that this
all that you must consider.
That goes against me only, my lord. My lord may consider doing 25, my lord.
No.
He will be able to pay, my lord, that amount. 35 will not be able to pay even by back borrowing steel, my lord.
We will grant you some reasonable time also.
My lord may consider doing it 30, my lord. He'll actually not be able to do it.
Parties. In the interest of both the parties, we deemed it appropriate to fix a lump sum amount as permanent alimony and close all matters.
They sought 25 lakhs before the Leonard trial court. I was not in a position to pay that also at that time.
Counsel, when I'm dictating, I don't like anybody.
I apologize, my lord, because he is
whether senior or junior or anybody.
I go down, my lord.
Just wait. When I complete my dictation, you can again start your argument.
I would not want to do that. Permanent alimony of rupees 35 lakhs, which will take care, which will include the areas also, outstanding areas of maintenance, with respect to which an appeal is pending before the High Court. Said amount to be paid in two parts. An amount of rupees 20 lakhs to be paid on or before 30th June 2025, and the balance 15 lakhs to be paid December 2025. Make submission, my lord. I'll end it there.
1 minute, Abhi, this is all complete.
Please, my lord, I thought this was complete.
2025. Full stop. Subject to payment of the said amount, the petition shall stand disposed of, and the decree of divorce granted by the High Court shall stand confirmed.
Well, there are criminal cases also, my lord. I file all the cases to be withdrawn.
Pending criminal cases between the parties shall also stand quashed. Details of the same, you provide the details of all the criminal cases against you.
I have, my lord. I have.
I'll do that.
I'll have.
But then,
I
have.
Details of which are given here under.
We'll give it.
The registry shall draw the decree and inform the concerned court of this order so that formal orders for closure may be passed. All pending dispute between the parties shall stand closed.
Including appeal, my lord. We don't have an appeal number.
The
He said
including the appeal before the High Court,
my lord.
against the maintenance order.
Yes, my lord.
And they have also filed against DV and Malad.
Everything was
I
done.
said.
Give details of all the cases.
Yes, my lord. Well, I'll give it.
Now to submissions. Number one.
Firstly, my lords, may consider reducing it, my lords. He's
Number two.
Two, my lords, if my lords are not agreeing to me on reduction, my lords, first, my lord, first payment I'll make by September, my lords. Second payment by March, my lords. In fact, my lords, is not in the financial condition to make payment by June, my lords. Till September, my lords, 20 lakh rupees, my lords. Till March,
All right, we will
Make it 3.
increase the installments and the time also. Wait. So 30th June tak 10 lakhs kar dijiye.
Yes.
please, my lords. That
Another 10 lakhs by 30th October, 31st October, and the balance 15 lakhs by 31st March 2026.
I'm good. I get it.
Okay, next.
I'm grateful.
my lord,
that please.
still asking me,
We'll
but
get
that's all I'll make again, my lords.
No, next case.
My lords, if possible, my lords.
Next case.
Lord, the matter was sent for mediation. It has failed.
Item 8, 7 हो गया? हाँ?
7th, 8th.
ये 7th है? ये 6th है?
Contempt है 7. 7.1. List पे तो नहीं है.
ये item 6 में क्या हुआ? Seven-year high. Neetu alias Nikita.
Contempt to close.
Contempt close कर दो.
Lord, by the impugned order,
yes,
the Honorable High Court has set aside the decree of divorce granted by the family court. This matter was sent to, for mediation, Lord, and mediation has failed, and thereafter the matter is before Lordship. Lord, the admitted position in this case is that for past 17 years, they are not living together. And Lord, there is no, at present, Lord, there is no child out of the wedlock. And Lord, for all practical purposes, this marriage is dead, Lord, and there is no chance of
what?
Lord,
do you do for a living?
Lord,
what is your profession?
They are poor farmers, Lord. Poor farmer. Farmer. He has no other occupation, Lord. Of divorce was granted by the family court subject to payment of rupees 15 lakhs. But
have you paid that amount? No.
No, that was challenged before the Honorable
That was challenged by her?
Yes, Lord.
Not by you?
No, not by us. Certainly not by me. But
what is the date of the family court judgment?
That date I'll give you. It is
June, July.
Judgment is of 7th July 2021.
About 4 years back.
Yes, Your Lordship.
Yes. What do you say?
My lord, my instructions are that she wants to stay with the husband, my lord. As far as the money is concerned, she doesn't want any element.
She doesn't want any.
No, my lord. She wants to stay. The matter was referred for mediation, but mediation, her only point is that she wants to stay with the husband. I leave it to my lords, whatever.
Continue.
My lord, we have tried our best. But
even in mediation, it has failed.
I completely leave it to my lord.
So you want a permanent alimony? We can increase that amount of 15 to.
My lord, I leave it to my lords on this because she doesn't want any alimony, my lord.
We will fix it. If she wants to accept it, she may accept. She may not accept it.
Whatever, I leave it.
Okay. 5 lakhs.
Lord, he's a farmer. He will have to sell land.
Whatever you have to
Beyond that, he has no other means.
You may not take it. You'll get back your money.
Lord, I don't want that. She should not take it. And it should be fair, not fair on my part, Lord, at least. So it should be 20, Lord. I will convince my client.
My lord, in the mediation, he has already offered more than 25 lakhs.
More than 25 lakhs.
Somewhat around 50.
He was there in mediation, Lord. And, it was there. It is not
that was
like
the offer, but my lord, she doesn't want it. The money.
Doesn't want it.
No, man. We leave it to my lords on this.
छोड़ दिया तो नहीं जाती छोड़ दो ना सर डिस्कस
देखिए third counsel for the parties. exercising clause number 142, we allow the disposal of this matter, the side involvement in the marriage between the parties, and fixing permanent alimony of rupees 20 lakhs to be paid within 2 months by the appellant to the respondent. ठीक है? फाइल भेज दीजिएगा मेरे पास.
Obliged. He's reached a settlement. Settlement agreement has been drawn. The only
Where's the other side?
they have not entered appearance. Although I have the document in Hindi, my lord, it says that they have to take steps to approach this court because we have to file joint applications.
You could have engaged one of your friends from the other side.
I,
That's how you always work.
I gave that suggestion. My lords, perhaps, my lords, I can give a
You
suggestion.
should be actually getting instructions from both sides.
I had.
Why would she be engaging a counsel?
I had a word. I had instructed him to do that. My lords, may I say a request for something? Let my
What?
In the settlement agreement, there is a clause that they would approach the family court for the purpose of dissolution of marriage. So lordships could record that it can be dissolved right here. Everything can be done here.
But
That
the
will
site's not here, Mr.
I will take fresh steps. It will incentivize them to come. I'll bear the
We
expenses.
are fixed. It will matter next week.
Please.
You make alternate arrangements.
I have been.
Appropriate arrangements, not alternate.
A word from my lords in the order, my lord, would help me in getting them here.
Okay, Mr. Padmesh Mishra, learned counsel for the petitioner, states that parties have already arrived at a settlement. However, due to some difficulty, the respondent has still not put in appearance. As prayed, a week's time is granted to make appropriate arrangements. This after one. You understand the appropriate arrangement? What is next case?
I'll file the.
This on next Tuesday.
Grateful.
Can I seek a short passover?
Item 10. You want a passover?
Lodge.
At least may have it any other day.
Any other day, yes. Next week.
Lodge.
Very well.
On the request of counsel for petition, this next week. Next.
Public.
My lord, learned amicus is in another court. Kindly pray for Passover. Yes, my.
Ms. Makhija,
He's on our legs.
what is this matter about?
Your Lordship, this is the matter about of the he has filed the appeals of the delay of 4,000 days.
The legal service authority.
Please, Your Lordship.
Idea about that e-prison software.
E-prison software, Your Lordship.
What we could see from whatever has transpired so far, that software, if applied properly, if used properly, can take care of all these issues.
That's right. That's right. Your Lordship, that is being monitored in.
We don't know how far the execution is.
That's right. That's right. But it should take care of it.
In some other matter.
Please. In Sonadhar.
Your
In Sonadhar.
Which court?
Court number 5, Your Lordship.
Court number 5?
Four. Sorry, four. I apologize.
Your Lordship,
Court.
that judgment has passed.
It is being monitored. It's being listed. Court number 4. But this issue is
This issue is slightly different in that sense. Your Lordship recalls in Suhas Chakma, in fact, your Lordships had passed those directions where an assessment was made of all convicts who hadn't, in fact, filed appeals. And reasons were sought from each of them. Those reasons were filed by NALSA, and we had placed those reasons. There is a judgment also after that. So there were several reasons because of which convicts had not filed those appeals. It was not necessarily access.
Please. It's not that software which we are talking about is not limited to filing of appeals. It takes care of parole applications.
That's right.
Meetings,
Everything.
It's a very
Everything.
exhaustive
That's
software
right. That's right.
which we developed in Rajasthan.
That's right.
Then the Supreme Court Legal E-Committee has also done something in that regard.
There was a demonstration also. We were part of that demonstration.
Precisely. So if that software is applied in the entire country religiously, probably these problems will be sorted out. What more is required thereafter?
No, once that is fully functioning, then nothing more is necessary. But the problem is that different states are at different stages of this.
Data and update migration of the data in real time.
That's
the whole issue.
That's the only issue. That's right.
So we need
that will take care of parole. That is being monitored.
Number 4,
please.
Your Lordship, seeking indulgence, Your Lordship has appointed the committee in Supreme Court. Your Lordship, after that, Ms. Makhija has filed the report for Your Lordship. In that, Your Lordship, Ms. Makhija is seeking some direction from this court for Your Lordship.
Where is she?
She's on her legs, Your Lordship. She's in Court 3.
Club this matter with that matter. If there,
Suhas Chakma is still continuing?
Your Lordship, judgment has passed, Your Lordship.
Open jail is continuing. This aspect is over, Your Lordship. It's been disposed of by a judgment. I'm carrying that judgment. That, in my respectful submission, takes care of these issues. See paragraph 32, page 31.
Yes.
Your Lordships have page 31. It says reasons given by convicts for not filing appeals. That's right. So this assessment was made. May I read that? Paragraph 32. NALSA in its report of 6/9/2024 has opined that the convicts who have not preferred an appeal had adduced the following reasons. 1. Convicts were not interested in preferring an appeal as they were satisfied with the current judgment and the order on sentence. 2. Convicts had served a substantial part of their sentence. 3. Convicts' appeal was rejected by the High Court and hence they did not want to file an appeal before the Supreme Court. 4. Convicts lacked the financial resources to prefer an appeal. 5. Convicts wanted to consult their families before deciding whether or not to prefer an appeal. 6. Convicts wanted to engage a private counsel. 7. Convicts had a fear of enhancement of sentence in the appellate proceedings. 8. Convicts had originally pleaded guilty to the offence and were hence not inclined to prefer an appeal. 9. Convicts had multiple cases pending against them. 10. Convicts were not willing to state any specific reason for not preferring an appeal. 11. Convicts had recently been convicted. Therefore, with respect to 1, 10 and 11, they were asked again. Because that is with respect to
the NALSA or Legal Service Authority apprising the convicts
That's
regarding
right.
the right to file appeal and assisting in that.
Assisting in filing all the way up to
What
this.
we are trying to say is that this data, you want physical presence in jails and then you take the prisoner's opinion. Rather than that, we feel that if there is a comprehensive migration of data of every prisoner, this should not be required.
It's underway. It is underway.
The pop-up will be there.
The pop-up will come. In fact, emails are sent in some states. For example, in Delhi, emails are sent to the prison superintendent saying that they are eligible.
So basically, the issue which is taken up in this matter is covered by this.
Your Lordship will wait for the learned amicus. I'm not
Your
certain
Lordship,
if he
kindly
wants to
see
say something
PDF
about
page number 1200. Your Lordship is a learned amicus seeking some direction from this court, Your Lordship.
Sonadar.
Can you bring the orders passed in Sonadar?
I'll do that. At 2 p.m. I'll bring all the orders because there are lots of orders in that.
Next Tuesday.
I'll do that. I can file that, Your Lordship, because it's a big compilation of orders. I can. I'll do that.
Ms. Makhija is occupied. Just again next Tuesday.
Obliged, Your Lordship.
Obliged.
So file print.
Wait, please, my lords.
Yes.
My lords, it's an appeal by a landlord, my lords. 31 years he is fighting litigation, my lords. I won from appellate court, my lords, first appellate court, finding of fact recorded in my favor that they are trespassers and therefore not entitled for the protection of statute, my lords. They cannot be termed as licensee, my lords. High Court, my lords, on first
Now, you filed a suit, regular suit for eviction or?
I filed suit for eviction, regular suit, my lords.
Regular suit for eviction.
My lords, I'll just brief the facts, my lords.
Yes.
I rented out property to one Madhuben, my lords.
Madhuben.
Madhuben filed suit against these present respondents in 1988 saying he is my brother. He came to my house for 4 months period because he was dispossessed from his house. Thereafter, he refused to left. I went to Hyderabad. Now I have returned and he is not letting me in.
Okay.
So, suit for injunction.
Collusive suit.
Milords, yes. She files a suit for injunction, Milords. Thereafter, he files a counterclaim in that, Milords. And then they enter into written consent.
You are not a party to that.
I was made a party. Then I came to know that this thing has happened because I was receiving rent from Madhuben. Then, my lords, written terms are agreed in which they agree.
Now your tenancy with Madhuben is in writing or oral?
That was also oral, but admitted, my lords. Admitted, no dispute. Since 1950s, my lords. And my lords, then upon coming to know, I issue a notice. I file a suit for eviction against them, my lords. Madhuben is also made a party.
Madhuben doesn't appear and contest.
She never appears because she has, my lords, taken whatever consideration, whatever, my lords. And in the written consent itself is recorded that she will facilitate transfer of tenancy in their name. Now, my lords, trial court dismisses it on the ground of that section 12A that demand notice has not been made in accordance with law, etc., my lords. First appellate court records a specific finding. They have failed to prove how they entered into possession with my consent because ultimately they have to be licensee, my lords, to this thing get a protection. Even subletting, that's okay. The contention was they trespassed, my lords. Trial court, first appellate court allows my suit. They filed civil revision. That is allowed. I come before my lords. My lords set aside that order, remand it back for fresh decision. Now it has again been decided. And that's why, my lords, I'm here, my lords.
Now, what does the High Court say?
High Court says 15A protection is available to them. They are licensee. And that is, my lords, something, my lords, which needs consideration of my lords, on two aspects, my lords. And since 89, they are not even paying anything.
You refuse to accept from them.
That's right.
My lords,
that's what the finding of the court says.
Of a trial court, my lords. Because I was, my lords, persecuting them as a trespasser, my lords. But they are leaving. Trespasser. And if they are trespasser, they are not entitled for protection.
Yes.
And that's my case, my lords.
The issue is something slightly different. He files a suit, my lords, for eviction on the basis of multiple grounds under the Rent Act. The trial court dismisses the suit. The first appellate court finds in his favor on two grounds. One is on the ground of non-payment of rent, that is under section 12 of the Rent Act. And second is under 13(1)(e) of the Rent Act, which is unlawful subletting. On these two grounds, the first appellate court finds in his favor.
How are you?
I'll just indicate. Please have.
What is the right of
so therefore, please have section 5 and section 15 of the Bombay Rent Act.
On facts, please. How you come into?
I come into the picture admittedly around 1965.
Around, forget about around. In what capacity?
Which is why
you don't dispute that Madhuben was the actual tenant.
Madhuben was the actual tenant.
I
come into possession, and which is why, my lords, I am stating that Section 15 protects anyone in possession irrespective of whether he is a lawful tenant or not. Please, which is why the matter was once remanded back. Please, therefore, my lords, have the finding of the court, first of the straight away of the High Court. Please have page 7. And
what is the extent of the property?
500 square feet.
500 square
feet in sign, my lord.
It's a flat.
It's in sign. Bombay.
Yes, my lords.
It's an apartment.
It's an
It's an apartment.
500 square feet apartment.
That's right.
And what was the rent you were paying?
123 rupees.
123 rupees.
That's right. But Manoj, on the legal issue, Manoj, please have the finding and kindly see a judgment of your lordship which says that lawful or unlawful possession is irrelevant if he's in possession prior to 1973, which is why your lordships had once remanded the matter back. The High Court had once decided against me, the matter was then remanded back. Please, for a moment, Manoj, have page 7. Page 8, I'm sorry. About para 13, about 4th of fifth line after 1965, my lords, has
Page 8.
Page 8, para 13, about 5th or 6th line from the top, my lords, after 1965.
Yes.
After 1965, she along with her husband has abandoned the suit premises. This is referring to the original tenant. Madhuben. Subsequently, in that suit on 10th October 2001, consent terms were arrived at between defendant number 1 and defendant number 2A to C. I am defendant number 2A. As far as B to C is concerned, my lords, it has been dismissed for non-prosecution. That is my second submission I'll make to your lordships as far as 2B and C are concerned. And other family consent terms were arrived at between defendant number 1 and defendant number 2A to 2C and other family members where the plaintiff therein accepted the findings recorded in the order dated 27th October 1993. The plaintiff therein declared and confirmed that she along with her family members left Mumbai in the year 1965. Defendant number 2, my father. Defendant number 2 was completely in control of the suit premises. It is no doubt true that the plaintiff herein was not made a party in that proceedings. Findings recorded at interlocutory stage as also consent terms will not be binding on the plaintiff, even if I exclude from consideration the proceedings of the City Civil Court. Nonetheless, evidence on record in the present case clearly shows that defendant number 1 had permanently shifted to Hyderabad in the year 1965 and defendant number 2 was in occupation of the suit premises from 1965 onwards. Defendant number 2 was in exclusive possession and control of the suit premises from 65 onwards. Defendant number 1 was not having control over the suit premises after she along with her family members shifted to Hyderabad permanently. Thus, one has to conclude that the defendant number 1 has parted with possession of the suit premises and created interest in favor of defendant number 2 in 65. Now, please see section 5 and 15, my lords, because that is what has been interpreted by your lordships also in another judgment. In this act, unless there is anything repugnant to the context, 511, tenant means any person by whom or on whose account rent is payable for any premises and includes A, such subtenants and other persons as have derived title under the tenant before 1st day of February 1973. Now please see 15 subclause 2, which is at the end of the page. Please have that. The prohibition against subletting. This is with regard to the ground of unlawful subletting. Prohibition against subletting of the whole or any part of the premises which have been let to any tenant and against the assignment or transfer in any other manner of the interest of the tenant therein contained in subsection 1 shall, subject to the provisions of this subsection, be deemed to and have had no effect before the 1st day of February 1973 in any area in which the act was in operation before such commencement, and accordingly, notwithstanding anything in the contrary contained or in the judgment or decree of a court, any such sublease, assignment or transfer of any such purported sublease, assignment or transfer in favor of any person who has entered into possession despite the prohibition in subsection 1 and purported sublease, assignee or transferee and has continued in possession on the date aforesaid, that is 1973, shall be deemed to be valid and effectual. Now, this clause, my lords, came up for interpretation before your lordships in a judgment, which is, my lords, I just pass on a copy, 2011 5 SCC 128. And please have para 27 of this judgment. My lords, says para 27 at page 138. Page 138. But then, may I just read that? But then came section 15.2 that removed the unlawful tag from any subletting, assignment, transfer or interest in any other manner or licensing, though contrary to subsection 1, that were made before the 1st day of February 1973. The second part of section 15.2 laid down that regardless of the prohibition in subsection 1 and notwithstanding anything contained in any contract or in the judgment, decree or order of a court,
a sublease assignment or transfer of interest in any other manner shall be deemed to be valid if the person in whose favor transfer is made entered into possession of the demised property and continued to be in possession on 1/2/1973. Therefore, my first submission is, my lords, if it is accepted that I came into possession around 1965, prior to 1973, then 15(2) will protect me from the contention that I was an unlawful sublessee, because the Act, insofar as 15(2) is concerned, will not apply at all. The finding of fact is that I have come into possession prior to 1973, and that, my lords, is shown by about 4 documents. Please have page 7, para 12 of the High Court statement. My possession as far in 1965. Please have page 7, para 12.
The current rent of such a property?
Milords, it should be more than 30,000. I can't say with Milords.
1 lakh rupees? 1 lakh?
Please, Milords?
1 lakh per month?
No,
that
it's not 1.
I don't know, Milords.
30,000 you will get Delhi.
It's signed, Milords.
Why signed?
Please, Milords. It could be more, Milords, but I can't, Milords, say without.
Take instruction.
I'll do that, Milords. I'll do that, Milords.
If Mr. Marial wants to continue,
Yeah, he should pay the rent.
he
That's
will pay
it.
the rent
Yes, Milords.
from the date of filing of the suit. When did you file the suit?
1991, Milords.
Yes. You have been enjoying the premises owned by the appellant.
No, my lords, there is a issue,
Last-
because at the end of the day, my lords, if the finding
We
is
are
that I
here
have...
to do justice between the
Oh,
parties.
that's right, my lords. I
You
quite see
cannot
that the
give
rent...
the landlord in lurch and getting 123 rupees as against
see,
the property
123, my
which
lords,
was
is,
fetched 50,000,
is certainly very
60,000,
inequitable.
80,000,
123 is certainly
whatever.
inequitable.
He passed
But-
away, Milords, fighting this litigation.
Ah,
Milords. That's the plight, Milords.
Everywhere it's the same.
Yes, Milords.
All right.
You also take instruction.
We'll also take instruction.
Otherwise you get.
We'll also take instruction. I'll take instruction.
And tomorrow? Friday?
Next week, your lord.
Next week. We will listen again on next Tuesday, that is 29th April 2025, to be taken up immediately after fresh matters. Fresh and bail matter. Huh?
Yes.
In the meantime, counsel for the parties may obtain instructions with regard to the current rent of the premises in question.
Grateful, Milords.
We'll find
current market rent of the premises in
123, I also see, my lords, is absolutely inequitable.
There are bungalows and bungalows with 1 rupee.
No, I quite see that, my lords, is rent tag.
101 rupee, 51 rupees.
That I quite see.
Didn't what I have.
Grateful.
Please, my lords. Once I kindly seeking a week's accommodation at number 17, my lords. The council is not
Any
available
objection?
today.
No. My lord, may I just make
counsel for petitioner list after 1 week.
my lord, may I just make a request, my lord? My lords may call for the records in the matter, my lord, if my lords are kind.
What is this matter about?
It's a specific performance suit, my
Why do you want the records?
No, but because they rely on certain documents, etc. Those documents are not on record.
File the documents.
We are
They have not
trying to
filed it.
try. Yeah, they have.
We had filed.
Why are you worried?
Okay. Yes.
Is their appeal?
Yes.
Their petition?
Yes.
Specific performance?
Yes, my lords.
You are
They have the
plaintiff or defendant?
Yes. I was the defendant in the.
Defendant.
I was the
Okay.
defendant, my lords.
You lost. Decree has been there.
Yes, my lord.
Purchases in possession, the sale consideration was 1,75,000. 150 you received.
Yes. So to continue more well.
Thing is, how much you make out of the remaining 25,000?
All right. Next week, well.
Next
All
week,
with the
you
instructions
come
on
ready.
that.
Yes, ma'am. Grateful, man.
You also come ready with instructions.
Yes, ma'am. Yes.
That you want to retain the property or you want to leave it?
No. I'm in possession, my lord.
Possession can be taken away also. Next.
Grateful, ma'am. Grateful. For respondent number 4 in this matter, we are seeking some time to file an affidavit in terms of the last order.
How much time?
2 weeks, my lord.
Counsel for the respondent place was granted 2 weeks further time to file the affidavit in terms of the previous order.
Much okay.
Most definitely.
Next.
Lord, I beg to appear for the petitioner.
My lords, a short passover.
My lord, here.
My lords, I
would like
request
to
a
serve-
passover, my lords. The arguing counsel is held up in another court.
All right. What do you want?
My lord, nothing. There is an exigency, my lord.
Huh?
My lord, many a times, my lord, it does not come back again.
Come back again. That's right. What is there is no urgency?
Yes, my lord.
What is the urgency?
My lord, what has happened is, my lord, out of one single incident, 2 FIRs, one in the state of Tamil Nadu, one in the state of Karnataka, has been filed. Now, what has happened is, my lord, charge sheet has been filed. Now, charge has been framed in as regards one charge sheet in Tamil Nadu, and it is.
Very good.
Yes,
You can start now.
my lord. I may be permitted to circulate a small compendium of cases.
Well. So many cases you need to rely upon. One should be not good enough.
Yes, my lord.
Where do you want the trial to take place?
My lord, charge is already framed in Tamil Nadu. My lord, the incident happened in Tamil Nadu. My lord, if I may take my lordship to
It's a
the.
video which has been circulated based whereupon the FIRs have been filed.
My lord, what had happened is an alleged inflammatory speech
Yes.
at the instance of the accused happened in Madurai at Tamil Nadu.
That's why that was circulated and based upon the FIRs being filed in
Yes, my
Karnataka.
lord. Yes, my lord.
Tamil Nadu, Madurai,
All the witnesses are from Tamil Nadu.
Yes.
Sir. And charge is framed in Tamil Nadu.
Likhi bhai, leave granted allowed.
Obliged, my lord. Will I be permitted to circulate a short note on the relevant paragraphs of the judgments?
Do that.
All right.
Obliged.
Parties may file small, brief notes.
Obliged.
Within 3 days?
Yes, my lord. Yes.
Within 3 days.
We have certain millets in the mediation. And as per the millets,
Matrimonial dispute?
Yes, millets. Millets has sent to mediate settle millets. 36 lakhs 50,000 millets I have to pay to them. Millets. There are 2 tranches millets. One is millets 26 lakhs 50,000 by 15th of May millets. Out of that, I have already sent to her 7 lakhs millets. And the next tranche millets I have to pay 10 lakhs by 15th of June millets. And millets divorce millets we have agreed for since they are residing millets separately since April 2010 millets. So we have agreed that millets may pass. Already may file millets 142 application also. So if millets may grant the millets.
And if you don't pay, then what happens?
Millets then can we revive millets?
Are you agreed for mutual divorce in terms of the settlement?
Your lordships were agreeable for mutual divorce, but subsequent to payment.
Yes, the decree will be drawn subsequent to payment.
Yes.
But we will
Yes, your lordships, we are
dissolve the
agreeable to
marriage.
divorce, your lordships.
The decree will become effective only after payment is made.
And but there's so many cases pending. All can be millets. Number 3 mentioned.
It is all mentioned in the
application.
142.
Yes, ma'am. In the millets mediation settlement.
All right. Please give by 142 application allowed. Marriage dissolved. The decree will be drawn only after the entire payment as agreed is paid and proof of deposit is filed before this court. Before the registrar.
Deemed to be closed.
And all pending cases deemed to be closed. Registry will forward the copy of this order to the concerned courts only after decree is drawn.
Deeply
Obliged, your lordships.
Item 21.
My lord, chiefs had asked for a report from AIMS. We'd filed that report by way of an affidavit.
Yes.
Yes, my lord. We have received the report, my lord.
Yes.
Unfortunately, AIMS could not come to the conclusion what is the cause of death
How
and
could
what.
it
My
be?
lord.
So nothing is available in physical form before the AIMS. Whatever material was provided, AIMS could have done its best. Yes.
My lord, I have taken out a IA. IA number 63866, my lord.
Yes.
My lord, this is in view of the report filed by AIMS, my lord.
Yes.
Your lordship, may kindly turn to page number 2 of my IA.
Yes.
At para 2, my lord. Sorry, para 3, my lord. The petitioner submits that on 3/2/2025, respondent number 9 filed its counter in the present SLB, annexing therein certain correspondence with respondent number 10 and respondent number 1, 2, and 3. My lord, respondent number 9 is the medical DMHU, that is Andhra Pradesh, and respondent number 10 is the AIMS, my lord. The petitioner submits the respondent number 10 filed its counter on 5/3/2025 in terms of the additional affidavit, annexing therein final opinion of the respondent number 10 on the correspondence of the respondent number 9 and certain treatment details to the deceased. The petitioner submits that after going through the counter and the documents therein filed by the respondent number 9 and 10, it prima facie appears that the respondent number 10 could not form its opinion as the record material, articles, videos, photographs, and visceral samples of the deceased was not supplied to the respondent number 10 by the respondent number 9, which is reflecting at page number 11 of the counter filed by the respondent number 10, my lord. The petitioner submits that the unanimous opinion of the medical board formed by the respondent number 10, which is reflecting at page number 11 at para 2 of the counter as follows. The medical board has only perused the documents submitted in the said matter without any interaction with the doctors who have treated the patient or the relatives for the disease. The medical board also does not have any knowledge about the medical facilities, qualifications of the treating doctors, and the infrastructure of the hospital where the disease was treated. Hence, opinion could not be drawn. My lord, here I will just explain, my lord. In the first line, my lord, the medical board has only perused. Only, I am emphasizing what the word only. Why? Because the viscera report has not been sent to them. Because the viscera was not sent to them. And on the first occasion only, my lord.
Mr. Counsel, the viscera was consumed in the examination way back when the incident took place. It wouldn't have been retained for so long. When he directed the examination, the board's, the IO sought opinion from the board. When did the incident take place?
My lord, the incident took place on 14th of July 2023, my lord.
You presume that the viscera would be still available?
My lords, I
No, my lord.
state, can I answer this?
May I complete, my lord?
Yes, yes.
My lord, incident took place on 14th of July 2023. My daughter was declared dead on 16th of July. 17th, that postmortem was conducted. And thereafter, the sample was sent for postmortem forensic examination, my lord.
Yes, sir. As pathology.
Now, my lord, as per the reply filed by the respondent number 3, who is the concerned SHO, says that in view of their indent order, indent request, they have not requested the RFSL Andhra Pradesh to preserve the viscera. Therefore, it was destroyed.
Naturally, they expect a report to come. The report comes, then why viscera is to be preserved?
My lord, my lord.
They presume that you will be filing a petition for CBI investigation so that they should preserve the viscera.
No, my lord.
In case of this nature.
No, my lord.
Then
what I am saying is that, my lord, in such a complicated case, my lord, in such circumstances, may I show photograph of my daughter, my lord? The lordship will come. Every entire case is here in the photograph, my lord. When a daughter, my daughter is going upstairs.
That is why we have asked the report of the AIMS.
My lord.
Now the report is there. The AIMS has based its reports on all the material which was provided.
Right, my lord.
Beyond that, what is to be seen? Your allegation is of what? What offense you allege?
My allegation is my daughter has been murdered.
Medical negligence. So if it is murder, then it is not medical negligence.
No, medical negligence, including medical, because my daughter has been murdered, half murdered in the hostel, and thereafter it has been completed in the hospital. It is my allegation from day one. From day one, 161 statement I have stated clearly, my lord. And I have given the names of those culprits also, my lord, in my 161 statement on 16th of July.
You will have the opportunity if the police files a report under 173.
My lord.
Closing the matter, you will have an opportunity.
My lord.
Yes.
Kindly see that report. Kindly see the
Well,
photograph.
you show it to the trial court. If you show it to the trial court, you convince them there.
No, but
we are not having a look at the matter under 190 of the CRPC.
I understand, my lord, but
Yes.
but what I am trying to say before this honorable court is that what police will file before the court. They concluded on 16th of July itself that it is a suicide. A girl going upstairs at 10:25 p.m. on 14th of July and she has committed suicide, whereas the girl fallen on 9:46 p.m. on the same day. How the girl can fall prior to 1 hour? How it became a suicide, my lord? You lordship, you can see the photograph. It is provided by respondent number 3, my lord.
We are not disputing that. We keep the photograph. We are only thinking as to what can be done by this court.
What is my case is, my lord, let me explain, my lord. My case is that my daughter was half murdered in the hostel, and they presumed that my daughter is dead. And to just manifest, they admitted her to the hospital. And thereafter, in hospital, she has been given poison. It is my case, my lord. Why I am saying so, my lord?
Why do you attribute that to the doctors in the hospital?
Exactly.
What is the
I am
animosity
saying,
of
my
the
lord.
doctors?
I am saying, my lord, not only doctor, hostel authorities, hostel owner, hospital, two hospitals and police. Everybody is hand in gloves, my lord. You lordship may kindly see page number 30, last page of my IA, my lord, at page number 29. Why I am saying so, my lord? This is the postmortem certificate, page number 29, my lord.
Yes.
Please. You lordship may kindly see under the column right hand side abdomen. You lordship got it under the column abdomen. Abdominal wall, nothing particular.
29 of?
29 of my IA, my lord. IA, my lord.
IA number?
63866.
Yes, sir.
63866 or 25.
68 plus. Is there?
Additional
For direction, we, Maheshwari and company are looking for the petitioner. We are number 14 for it. 13.
For the sake of our window lordship, kindly see, it is my daughter, my lord. If I am cannot.
No, we are
sympathy.
My lord, you. We are trying to examine it. This is not the first day. We've been dealing with it for the last at least a dozen times. Yes, page 29. What do you want to show?
You lordship, kindly see here. Under the column abdomen, my lord. Stomach and contents, my lord.
Yes.
About 80 grams of brown, yellow, and white mixed semi-digested rice food noted. Mucus congested. Suspicious smell noted, my lord. Your lordship may kindly emphasis on the word suspicious smell noted. My daughter had her food at 8 p.m. on 14th of July. She has been declared died on 16th of July. Still, there is a 80 ml of yellow, white mixed and digested rice food noted. And my lord, metabolic time for the digestion is 3 hours. That's why I wanted to show this diagram, my lord. This is the body anatomy of a human body, my lord. This is the esophagus, stomach, and thereafter small intestine, large intestine.
What does the viscera report say?
Nothing is with me, my lord. That's why I have taken this IA.
My lords, we will file, but we have it. It's part of the case diary. And as my lords noted, the viscera examination was done. No poison. It categorically states no poison, no drugs, no alcohol. And thereafter, only as per the procedure, my lords, viscera was not preserved.
Tell us, how do you explain?
Yes,
whether she was given solid food during the time she was admitted in the hospital? She could not have. She was a patient of severe brain injury.
Yes, ma'am.
How could she have consumed solid food?
My lords, we will get instructions on that.
All right, you come after lunch, we will take it up. Post lunch. Where is Mr. Patwalia? Yes, Mr. Mehta, what are these two matters?
Lord, these are the matters regarding High Court building.
Yes, what is your
Lord,
problem? Tell us.
yes. Lord, let Mr. Patwalia be here.
Hey, Mr. Patwalia.
I
Mr.
would
Patwalia,
like,
we had appointed him.
Lord,
Our request that he was there.
yes. So far as the first matter is concerned,
Yes.
Lord, in both matters, my Lord, so far as the parking is concerned, there is a need for parking. There is no difficulty. We are not objecting to that.
And in the other matter, there is a need for a little shelter. That's all.
No, Lord, then the difficulty is, my Lord, this is a World Heritage site. Lord,
Now, the enclosure, Mr. Gupta, please show the photograph to Mr. Mithaus.
that I have seen that. But that was in existence when the World Heritage Site title was conferred. Lord, we can do nothing at the cost of that title being taken away. Let us take the permission.
Instructions of the High Court, finished. Direction of the High Court, you comply with it.
But that doesn't bind the World Heritage Committee.
Very well.
Lord, the High
How
Court,
does it matter? How is the World
it
Heritage
matters to the nation.
What?
The High Court should not have done anything, my Lord, which takes away, which has the.
How long
My Lord, allow me to argue.
Committee take to
Lord,
respond to your communication?
I'm sorry, my Lord. If suppose High Court says that tomorrow that change the position in Taj Mahal.
No, it's not
And
that.
if Taj Mahal, my Lord,
Exactly that.
Practical.
Lord, then I would like to, my Lord, argue them.
Yes, you please argue. We want you to argue the matter. That's why we are called you.
Not today, my Lord.
Why?
Not today, my Lord. I was called, my Lord, and therefore my High Court is more eager, my Lord, than the bar. It is for the bar, but bar is, my Lord, also not.
Bars keep changing, you know.
My Lord, High Court also.
Presidents keep changing, the executive committee keeps changing, and everything keeps.
My Lord, the honorable.
My brother.
Given an example of what happened in
What
Rajasthan.
happened in Rajasthan?
One protest from the Bar Association resulted into the building being delayed by 16 years. So,
But fact specific issues, my Lord, your lordships are right. I bow down. But, my Lord, the country would not like to lose the World Heritage Site status merely because, my Lord, two honorable judges feel that there should be a change.
You are not denying that the requirement of that shelter is going to help everyone?
I do not, my Lord, nobody wants. Lord, my Lord, let me not take, my Lord, an adversarial stand. Let me take permission from the committee and do it. I would not, my Lord, accept.
How much time will you take to take the permission from the committee? Since when have you applied to the committee and the committee is not responding? If the committee doesn't respond for 100 years, what do you mean?
We have applied. We have applied. We'll expedite the, my Lord, process.
When did you apply? We want
Lord,
to
immediately after the High Court's order.
When do you want this matter to argue? You want to argue this matter? When? You say you don't willing to difficulty in arguing to today. When would you like to argue?
There is a special bench at 2.
All right.
In court 3, my Lord. That's
We are
the.
asking you when? Tomorrow, day after, Monday, Friday.
Next week, any date.
Tuesday, next Tuesday?
Next Tuesday can be done. And I would request, my Lord, High Court also can't take an adversarial stand, my Lord.
Yes, sir.
It's equally important for the High Court as an institution that the building doesn't lose the status.
So Mehta, what they are saying is that water comes in during rains in the courtrooms because of this small shelter not being there. See the difficulty. It's apparent.
High Court has no personal interest in it.
Randomly is apparent. The 9 courts have that veranda and 1 court doesn't have. What is the logic?
My Lord, I'll, my Lord, address on that, but I would request High Court not to be adversarial. They will also try not to be.
I'm not saying the word.
High Court will come and appeal. High Court hasn't. You have taken it adversarial.
Lord, High Court has done what High Court.
Mr. Mehta, you should ask that question to your client, please.
High Court has directed us, my Lord, it would not come in the appeal. High Court is.
Doesn't want any direction from the High Court. It is.
No.
Ego is
We are bound, my Lord. I'm just answering why High Court has not come. High Court would not come because it's
No, that's
that
what
order
we have taken.
under
Don't-
challenge.
Don't put that to the High Court. That High Court is adversarial in this matter.
No, I'm
High Court is not
requesting him not to
adversarial.
be adversarial.
I'm not even saying a word.
High Court is trying to look out for the interests of the litigants and of course
I'm sorry,
the
I'm-
courtrooms itself.
But I'm sorry, your lordships have not, I could not convey myself.
We'll-
I
we'll
said
let
my
you know.
learned friend may not take adversary.
He is not at all. And
Then my request is accepted by him. High Court doesn't come into the picture.
All right.
But
Next Tuesday.
very few buildings have national heritage, world heritage
UNESCO heritage
tag, UNESCO heritage tag. Nothing should be done, in my respectful personal view, which takes away that tag from our country.
Always convince the UNESCO heritage.
That we will do.
This is a requirement.
That's the
need of the hour, and therefore we have done it.
That's the
without changing the total facade. Or
No, that's the only thing I am requesting. That let us do it after taking their permission. That's all.
The Chandigarh administration has
Not
taken so
because
far.
there is a mandamus, but mandamus also
Mandamus has not come like that. The court had been monitoring it for dates after dates after dates after dates.
I am not
preemptory orders.
And thereafter, if the Chandigarh administration sleeps over it,
No,
then
we
they
are
will-
not sleeping over it. But I'll show.
That's what we will examine to the next day.
Yeah, please examine. And I am not opposed to the idea, but not without the permission.
On the request of Mr.
The bottom line is we
Mehta-
cannot lose the tag of World Heritage Site, UNESCO Heritage Site.
That is Solicitor General. List this matter again on next Tuesday, 29th April 2025. To be taken up immediately after the fresh matters, and one matrimonial matter we have fixed. No? Matrimonial matter which came? नहीं वो specific performance वाला क्या Mr. बढ़िया आने immediately after fresh कर दिए one by one हो जाएगा देखो फाइल में
That's the parking matter, my learned friend said he has no difficulty.
He has no difficulty.
So that may be left out. Because
No, I am saying not without permission from the. Don't do this. Don't do that. I just now told you 5 seconds back. 5 minutes back.
You said
that I have no. I am not objecting to the parking requirement, but not without permission from the UNESCO heritage
UNESCO
site.
doesn't need to give permission for that. Not at all. That is not required.
When I am saying it's required, there would be some responsibility.
hear you on that also.
Just 5 minutes back,
No, but there is no such
therefore,
requirement.
there was, my lord, there was a purpose why I requested him not to take adversarial.
No, I'm not taking
We had a discussion, my lord, on 10 minutes.
You also provide a copy of your today's petition to Mr. Patwalia.
And to me.
Ask your
Don't have the
AOR.
second.
I will provide you everything.
Very well.
You are the God, my lord. I can't.
Mr. Patwalia also he was wanting.
Your lordships are, my lord Justice Vikramnath is aware, bar was not taken in confidence when Gujarat High Court building was made.
And that's one of the worst buildings there.
Exactly. I didn't want to say that. I didn't want to say that.
I wanted the architect to be sent to jail.
Even in Rajasthan,
Whoever selected the architect who designed the High Court building at Gujarat, Ahmedabad, should be sent to jail.
Lord, I will tell your lordships.
You must be a party to all that.
No, I was. It was 98, 99.
Still you were.
No. Lord, I went in one of the meetings as a driver of my senior.
My lord.
He couldn't drive. So he said, I was not invited, but my senior was invited. He couldn't drive. So he said, you take. But, my lord, your lordships will be shocked.
Great degree of satisfaction. Rajasthan
Lawyers have nothing to do with the design of the building. It is the architect who is responsible.
Exactly. My lord,
Don't say that because lawyers were not consulted, therefore that building has come up like that.
We could have said that this is
Lawyers
not.
are not architects.
Lord, when we were called, ultimately after the building was made, the architect explained to many senior lawyers, Mr. Shetna and Mr. Vakmai senior, that I have provided for, that I have huge space available, why not to have a bar room? And everybody blasted him, that in a High Court building, bar room is an essential part, not that you are doing the charity.
Yes.
So therefore I say that architect should be sent to jail.
Your lordships would be surprised when we shifted, the registry of the court gave us maps that from court number 1 to court number 15.
Mr. Mehta, Rajasthan High Court building is not like that.
Yeah.
Everyone is very happy, very satisfied. The
But
situation
we
prior
really-
to that is that if you parked in the old building, which is again a heritage building, if you parked your vehicle at 10:30, you couldn't get it out before 5:30. You were stuck there.
And the new building is
Here
completely
we
the opposite. It is more
We
spacious.
used to, my lord, complete our board with the map. That now 1 to 9 we will have to go down, then take a lift, then walk, etc. etc.
So that is a SOP.
And when it was, my lord, inaugurated, Justice, my lord, the then Chief Justice said that it looks more like a fort than a court. Obliged to, Lord.
एक बज गया कॉल कर दी किसी को टाइम नहीं चाहिए तो
22 minutes.
Yes.
This matter, we settled at mediation. Matrimonial dispute, Milord.
We have filed the joint application for divorce as per settlement.
So, Lordship convenience, Milord, one chart has been drawn out pending litigation and what is to be done in interstate parties. Milord, may I circulate?
Sir. Both sides are here.
Both sides are here.
Settlement arrived at terms complied with.
No, no.
Or to be complied with.
Part compliance to be complied with within 60 days. Last two pages, Milord, I have drawn a tranche. Page 4, Your Lordship may have. Bottom says obligations of the parties.
Yes.
So this first is done, Milord.
All right.
20 is handed over today, Milord. Remaining within 60 days is the next stage.
No. 10 lakhs you have to pay
through DD.
10 lakhs DD, Milord, handed over. 10 lakhs worth of gold ornaments, Milord, handed over.
Handed over.
That part's done.
Then number 2 is from 22nd April, 60 days.
Please.
15 lakhs and gold worth 19 lakhs.
19. Ornaments worth 19 lakhs.
Third one is.
And then third is 36 postage checks.
That happens on the same day.
On the same day.
Please.
Within 2 months.
Within 2 months.
We will listed after two.
IA number
98032.
9803225, 2024.
98032.
Just a second, I'm still pending.
Please allow kar di.
Just one request, Manoj.
Yes.
While quashing, Manoj, the matters interstate the parties, Your Lordship may add a line by interstate the parties as well as their family members. She's the complainant and all, let that family members work. That's about it. And divorce, Manoj, both of them.
No, you have given the details of the case.
Yes.
Details are
All
given.
these cases will be quashed. Finished.
Yes.
By the parties as well as their family
Yes,
members.
entirety.
That's about
Case is entirety complete.
Please.
Yes. Allow कर दीजिए.
Deeply.
To be quashed.
Your Lordship,
Same order से पहले किया है. Decree to be drawn only after complete payment is made and proof of deposit is filed before the registry.
Your Lordship, Your Lordship,
And cases to be closed after thereafter.
Your Lordship,
Lord, item 25. Sir, my learned friend Mr. Goel is here. Lord, I'm in a special bench in court 3. My Lord, there is a special combination sitting. Can be kept, my Lord, after 2 weeks.
25.
25, my Lord.
3 matters.
Yeah, yes.
All right.
Request I had, I made it on the last occasion also. The High Court had directed an inquiry. The solicitor said that he will place the report of that inquiry. He has filed a reply stating the essence, but that report has not come.
Report? No, you can't file an object. Let it be argued.
It's already passed, but we are not hearing arguments. Are
Yes,
you
sir.
giving an adjournment or not?
No, I'm just saying that please give a.
We will consider all that on the next day.
Yes, sir.
Your Lordship.
We don't know what it is. He doesn't want. He wants to file it or he doesn't want to file it. Whatever it is, we will hear it on the next day.
No, I have seen.
He says he never said that.
No. Lord, I have seen, my Lord, the report, my Lord, there is nothing secret in the report, but strangers can't sit in appeal over it of a former judge of the High Court and say this is the difficulty. We appointed a judge of the former judge to examine everything.
Second on next Tuesday.
No, not next Tuesday, bro. Next to next, if you allow.
Next to next. It's all right. Next to next Tuesday is 6th.
Lord, instead of 6, can it be on 9th, my Lord? The 9th would be a final hearing table.
So July. 9th is Friday.
This can go in July.
July was.
I think this can.
Before vacation, I want a copy of the report. I'll be able to persuade your lordship that.
But there is nothing, my Lord. It's a matter of inquiry, my Lord. It's
Whatever it is, at least he wants an opportunity to argue. We are seeking a adjournment. We will fix a date.
So next week, my Lord.
Next week. Very well. Next week. 29th.
Your Lordship, may I please mention an urgent
Not
matter?
now, we'll come back.
Your Lordship, there is urgency of demolition, Your Lordship.
Demolition.
Your Lordship, 1 minute, Your Lordship. Your Lordship heard the matter on 17. Your Lordship gave the liberty to go back. The slum rehabilitation matter, Your Lordship. 22 tribal people. Your Lordship gave the permission to go back. We filed review. Review was heard today and it was dismissed, Your Lordship. Your Lordship, I'm filing. They have not granted any stay, Your Lordship, further stay. The bulldozer are outside. They are demolishing within half an hour, Your Lordship. Your Lordship, I will file the MA in the disposal of matter. Your Lordship, may I hear it on hear it at 2 o'clock, Your Lordship, because all the properties.
Orders on oral request, no.
If I may mention, item 24, Miss Meenakshi Roda has fallen ill. She was on her legs in port 4, has been rushed to hospital.
What
So
happened
I'm
to her?
just 20.
What happened?
I'm here. I was
Mr.
told.
Mehta was appearing for the other side.
No.
No, I am appearing, not that great.
My
No,
lord.
in that case.
Yes, my lords. The society, the home buyers.
I
My lord, she was in court 4. She has been right now rushed to the hospital.
No, I was not appearing opposite. My lord, in that case, I would have fainted. With this combination, I would have fainted. I would like to know who she was opposing.
When do you want it?
My lords, next week, my lords.
Next week. Next Tuesday. Hey, you will not let us go. What kind of bar is this? Is here anybody who knows about what happened to Miss Arora? Is she all right? You were informed that for lunch that she fainted or something happened in the courtroom. Taken ill and she was rushed to the hospital. None of you know. All right. Yes.
My lord. My lord, let me start by making a submission of one line, my lord. As per police, concerned police station, a girl going upstairs on 14th July, 10:25 p.m. having a
What is
dress.
the basis for this statement of police?
My lord, I'll complete and then your lordship will get everything, my lord. Having a dress up to knee, white color top. And they are saying this is my daughter and she has jumped from terrace and thereby it is suicide. Another photo supplied by the same police station, the girl lying downstairs in the basement at 9:46 p.m. 14th July. That's why I wanted to show this photograph, my lord. This photograph is disclosing everything, my lord. 9:46 p.m. 14th July, that girl is lying downstairs. And
Having
she
fallen down from the terrace.
Yes.
According to them.
According to them. It is 9:46.
So according to them, one stand is that she had jumped from the terrace before 9:46.
No, 10:25. एक घंटा पहले 1 घंटा पहले सर
9:46 पे the body is found and the floor
Yes.
of the ground floor,
My lord.
then that means she had taken the jump prior to that.
Prior to that. And,
Correct?
and another photograph they are showing she has gone upstairs
At
at
10:25.
10:25.
All right.
Now, my lord, how it is possible, my lord? Your Lordship, may kindly see the photo. It is supplied by police. I am not. It is not my photographs, my lord.
Take the picture.
These entire photographs will disclose the entire case, my lord.
Please give us also, sir. Excuse me.
Yeah. Sorry.
This is from CCTV.
This is CCTV footage.
Yes, my lord. It is supplied by police. It is on the record of the Andhra Pradesh High Court, my lord, in a hard disk.
22, 25, 94.
My lord.
14 July, 14 July, 22, 25.
First photograph, a girl going upstairs. Your Lordship, may kindly see the dress up to knee, white color. And second photograph, Your Lordship, may kindly see girl fallen down, having a t-shirt and half pant. And t-shirt is a blue color. Your Lordship, kindly see. It is supplied by police, not my photograph. And that timing, Your Lordship, may kindly see.
Just tell us. We don't know about the position of the building, etc. How could this body be here in this lane? It's not directly accessible from the top.
Exactly, my lord. It is next building, my lord. It is
Which is the body?
building.
Which is the body as per you in this? We don't understand. This doesn't has not very clear.
Yes, my lord. It is supplied by police, my lord.
No, but how do you say that the police are claiming that the body was lying here in this passage?
I am not saying it is said by police themselves.
Where?
And thereby they made it a suicide case.
Photograph, as per the police, where do you suggest that they have shown the fallen girl?
It is like that, my lord. It is like that, my lord. It is for police. They are saying like that. 9:46 p.m. She is lying down in a half pant and t-shirt, having blue color t-shirt.
Blue color t-shirt.
Yes, my lord. At least that can be seen, my lord. And 10:25 she goes upstairs in a white top.
But how could she have committed suicide, fallen here from the terrace?
And that is also next building, my lord. Not this building.
This is the next building.
It is next
Do you have
building. Near about
any description?
this much distance.
Any description anywhere which shows that this is the photograph of the body lying there?
Nothing, my lord. Nothing. That's why I am here, my lord.
Wait. Mentioning this fact from that this photo pertains, or police has claimed that these two photographs.
Exactly.
Where?
Police.
Where do we get it from?
In their case diary, have they mentioned anywhere about these pictures?
In their reply, they does not speak anything about this, my lord.
Saying that these are the pictures.
But this photograph has been supplied to the court commissioner on the order of the Andhra Pradesh High Court, and the Andhra Pradesh the court commissioner submitted before the Andhra Pradesh High
There
Court.
must be some rough sketch or memorandum prepared regarding these photographs.
My lord, I have nothing to say, my lord. I have nothing, my lord. That's why I am here. I don't have viscera report. I don't have forensic report. I don't have the opinion of the doctors which committee was formed by the police, 6 doctors committee, to know the cause of death as well as the medical negligence. So what I am praying here, my lord, to know the opinion of 6 doctors committee that which was supplied to AIMS to form their opinion, and the viscera report. This is my idea, my lord.
All right, Likhiye.
My lord, one more submission before your lordship dictates. The dress of my daughter has been destroyed by the respondent number 5.
Who is respondent number 5?
Respondent number 5 is Venkatarama Hospital, on whom my daughter was admitted on 14 July at 10:30 p.m. And I have the videograph of my daughter on my deputation. My friend's driver visited the hospital at 1:15 a.m. on 15 July. She is talking, she is asking for water. She is asking the doctor, I want to talk to my father. I have the videograph in the pen drive, my lord. So, my lord, my daughter was speaking at
You have mentioned all this in your petition?
My lord?
You have mentioned all these facts in your
Everything is there, my lord. And there is no denial. I have clearly stated that my daughter has been murdered by respondent number 5, respondent number 3, respondent number 7, and having hand in gloves all together. And if it is false, my lord, they would file defamation against me right up to now. I am claiming this since 2003 in the Andhra Pradesh High Court as well as here also, my lord. They did not dare to file defamation against me. And I have time and again stated, my lord, that my daughter has been poisoned in respondent number 5 hospital. And that's why her that food is not digested, my lord. 3 घंटे का टाइम लगता है सब खाना पचने के लिए स्टोमक में.
हॉस्पिटल वाले क्यों पॉइजन करेंगे बताइए हमको. Why would they?
Because my lord, of the record, let me say, in the hostel there is some illicit relationship going on with the hostel owner or with the students. And my daughter was knowing everything. And she was like my nature. Every time it is protestive. And before to that incident, my lord, her 6,000 rupees has been stolen from her purse. So she was hesitating on that. Therefore, she has threatened the hospital authority that if you don't return back my amount, I will tell everything to my parents. And my uncle is a Bombay High Court advocate. It is my submission of the record, my lord.
My lords.
So what I am saying today here, my lord, that opinion of that 6 doctors, what they have given, because my lord, another statement I am making of the record, my lord, one of the senior most doctor in the panel, he came out after examination because I was also there, my lord. I was also called for that inquiry on 19th of September 2023, my lord. So after completing the inquiry, he came out and informed Mr. Shah, your daughter has not been died because of that multiple injury. What is shown in the autopsy report, the reason is something different. That much he has informed. I don't want to disclose the name of that doctor. It will come under 311 before the trial court, my lord. It is something different. And different, what, my lord? That suspicious smell, that viscera report has to disclose about the suspicious smell. As on today, I am blank. I have nothing. At least as a father,
Already.
The petitioner Sukhdev, what's your good name?
My younger brother, my lord. Okay. My younger brother. His daughter means my daughter, my lord. DNA is same.
Yes.
Okay. I am residing in Bombay. He is residing in Kolkata, and daughter was in Andhra Pradesh.
That doesn't make sense.
All right. Dekhiye, heard counsel for the parties, order is reserved.
My lords, since a query had fallen from my lords, just one thing, my lords, on the aspect of undigested food, my lords, in a state of coma, digestion is delayed. In a state of shock, my lords, may I just hand over Modi's medical jurisprudence on that?
Undigested rice can't be.
40 hours, my lords, that's what Modi's medical jurisprudence says. But behind my lords.
Very good. Thank you.
Obliged.
Obliged, my lord.
What had happened to her? She fainted.
What is not possible?
Which court number? Court number 4. And who was the counsel for the other side? Achha. But now she is all right.
Yes, on that.
All right. Yes, next.
Lordship.
Milords, despite the contempt, the money is not
Lordship.
going forward. Milords, I am saying with greatest respect, Milords, because she has been coming time and again and there is no money coming forward. Milords, my client has lived with the husband, Milords, for 10 years. Milords, kindly send him to jail for a month. The entire money, Milords, will be coming forward in a go. With respect, Milords, since I have been
All right, all right. Hey,
Lordship, please.
your item number is
35.
35.
Contempt is already issued, Milords.
All right, all right. Wait.
Last time the council had informed your lordship that Milords, when your lordships directed that to bring the toothbrush, etc. Lordship Justice Mehta.
Just 2 minutes.
In that, in Milords, the Mr. Manish Gupta said that he is ready to make the payment. Milords, Milords, I say it on oath.
Please, 2 minutes. Let my lords go through the order.
Yes.
Lordship, I just before yesterday I was informed that the petitioner has suffered a brain stroke, Lordship. He is admitted, respondent, sorry, Lordship. He is admitted in ICU, therefore, Lordship, he could not appear before this honorable court, Lordship. Lordship, on the last date, Lordship, I have stated that he is ready to pay 10,000 of maintenance. And Madam is saying I was telling I was petitioner.
Milords, I don't tell lies.
No, everything is recorded in the order. We have said that he has to come back and tell us how he will make the balance payment of 20 lakhs, how much time he wants, in what manner. And further, he will come ready with a further amount of 5 lakh rupees. That is the order. There is no statement of the council recorded regarding that he is ready to pay the 25 lakhs. The statement of the respondent is recorded that he is drawing 27,000 as pension and he is willing to give 10,000 per month to the petitioner. That is recorded in the order. All right. Now, he says that his client has fallen ill. देखा भाई कहाँ brain surgery? Stroke हो गया. Super Specialty Hospital, Korba.
Milords, he is a moneyed man, Milords. With respect.
Wait. We have heard all this on the last occasion. Thereafter, we had passed the order.
Lord, I'm so sorry.
Condition, it is difficult for the council also to get anything and for the court also. If he is hospitalized in ICU with a brain stroke, some time will have to be given. We'll fix this matter after 4 weeks and get a fresh report, status report about his medical health. This address
Copy of
given.
this so that I can also verify that whether he's
Yes.
in ICU or not.
Yes, yes. We'll provide you. We are mentioning everything in the order.
Lordship, please.
So you can verify it from there.
Lordship.
You don't need a copy of this report.
No, Milords, where is he admitted?
Yes, yes, we'll mention that.
I will give it.
Give a copy, right?
Give a copy to us.
I do not have, I will give it.
I will have to ask from him.
No, I will give. We will give you one copy, madam.
Take a
Please.
snap out of it. Take a picture of this.
You may not have to ask him. Take a
picture
photocopy.
of the phone.
What
Scan
must
it from the phone immediately.
No, they have a
Copy,
photocopy.
they have photocopy.
आप order लिखिए.
Lordship, one thing I want to say, Lordship,
हाँ.
I should not say, Lordship. In a legal aid matter, why I was seeing first time Madam is staying so
Madam
much.
always argues like this, with full sincerity, with full heart, nothing. She leaves.
No,
She should also understand.
It's not her concern. She is a true advocate. So don't make any comment on that. I've heard her many times.
You should try to learn from her.
The commitment to the profession.
For the profession and the clients.
Fighting for justice for your client. That's what she's doing. Truly, yeah. Nothing. No adverse. Yes. लिखिए भाई. On 4th April 2025, we had passed the following order. Quote कर दीजिए. Today, when the matter is taken up, you are Mr. Manish Gupta.
Yes, please, Lord.
Mr. Manish Gupta, learned advocate, appearing for the respondent husband, has placed before the court one certificate issued by New Korba Hospital, Mangalam Vihar, Kosabadi, Korba, bracket में Chhattisgarh, dated 20th April 2025, and further a CT scan report of GB Diagnostics situated in Korba. According to the certificate of the hospital, the respondent Arun Kumar Das, son of Mr. Dev Das, aged 62 years, male, resident of B-136, Urja Nagar, Dipka, is admitted in ICU in the hospital on 19th April 2025, having weakness in right side of body with slurred speech and deviation of mouth, and was diagnosed as a case of CVA, capital C, dash ischemic stroke with hypertension and diabetes. Full stop. The CT scan report suggests variable sized hypodense lesions. ये ऊपर वाला प्रोग्राम पर पॉइंट जो है ये कोट कर दिएगा. ठीक. Mr. Gupta, learned counsel, thus submits that in view of this development and the medical condition of the respondent, firstly, he is not present today. Secondly, he has not received the draft of rupees 5 lakhs, and he has no further instructions with regard to the mode of payment of the balance amount of permanent alimony. He has prayed for matter being adjourned and to be fixed after 4 weeks at least to enable him to obtain further instructions with regard to the medical condition of the respondent. Please. So, a copy of the certificate of the hospital dated 20th April 25 and the CT scan report of 19th April 2025 are provided to the counsel for the petitioner so that the petitioner may also verify and find out about the true status of the respondent. Let this matter be listed again. On 21st May 2025.
Much obliged.
I am for respondent number 2, and outside I have a technical submission if my lords allow me to say.
Item number
23.
23.
May I?
Yes.
My lords, petitioner has made respondent number 2, Mr. Umesh Mishra party, it was a private party. And when the matter was in High Court, High Court suggested then that the police station should be made party instead of the ION person. And they filed an amended application to that aspect, which is still pending. Now, their difficulty would have been if they changed the memo in Supreme Court, the matter could not have been listed. Now, my lords, I could get transferred or this investigation could go out of my hand in case this case gets prolonged. Then I suggest that infirmity could be rectified here also, and the Criminal Investigation Department, Gwalior, could be made the respondent number 2 instead of party.
My lord,
Because the ATR needs to be filed and a private counsel will not be able to assist the court the way state counsel could have.
You are not appearing for the state.
I'm appearing for the state.
It is represented. What is the problem?
My lords, he's for the chief secretary, but the ATR is...
the state principal secretary. You will be representing every department in the state. Why you are taking?
I bow down to my lords.
The state has filed its counter affidavit. The present application now is only for the limited purpose of grant of bail that the other side is seeking. In the counter, we have indicated there are multiple antecedents. Entire chart has been provided. There are 14 cases against him.
In how many of them were they recovered, registered after his arrest? Tell us. Wait a minute. I have some idea about the background of this caste and how the people are entangled in cases. Mr. Joshi.
Please,
Let me tell you, the adjoining areas of Udaipur, Banswara district with MP, there's a rampant practice to involve these people in as many cases as you can. Tell us, where is the chart?
Yes, page 8 of my counter affidavit. Para 8.
It shows the dates. When
Yes.
was he first arrested?
Yes, please.
Is he named in any of the FIRs? He would not be. There must be all FIRs of theft, so far as my information goes. Mostly theft, or then you have that weapon of 399, 400. 5 आदमी बैठकर बात कर रहे थे. Standard practice. Yes,
At page 10 also.
What is the relief you are seeking now in this petition?
My lords, the primary relief we are seeking in the petition is that the petitioner be granted bail in the cases in which he is presently in custody, in which he was
Who is
arrested.
the petitioner? Petitioner is not Gangu.
The petitioner is Gangu.
The mother and the...
Is it a habeas corpus petition you are filing?
No, my lord, the petitioner is Gangu's wife. What happened is we were filing the petition before the High Court also in Gangu's name. However, in fact, I have pleaded that in the petition and attached the local advocate's affidavit. The prison authorities, my lords, went out of their way to stop the advocate from getting Gangu's signature on the affidavit. In fact, subsequent to that, he was taken out of prison and beaten up, due to which the High Court passed an order transferring him to outside Pune district to a different prison.
He's the brother of deceased.
The uncle of
Uncle
the
of the-
deceased.
uncle of the-
He's the uncle of the deceased and an eyewitness. My lords, the startling thing is the magisterial inquiry report holding that it is a homicidal death. The report was signed in September of last year. An FIR was registered. We have an eyewitness, my lords. However, it just says 7 police officers. From September 24, we are now in April 25, my lords. Not a single police officer has been arrested. There is an FIR under 302, my lords. After that, they were serially arresting the
And
Gangu.
why have you pleaded respondent number 2?
My lords, he was
The main allegation is against him.
No, my lords. Respondent number 2 was the IO who was supposed to investigate the FIR into the homicidal death, into the custodial death. Therefore, we also pleaded respondent number 2.
No malified allegation.
No. Except that nothing is happening, my lords.
That's
no
right.
police officer has been arrested. They have been serious.
Mr. Joshi, you are appearing for?
I'm for the statements. Respondent number 1.
Minister of Police and your Home Secretary. Call them. When?
Because I'm here to assist, Mulus.
No.
If any instructions are to be taken, we'll take, Mulus.
What is success you have today, you tell us? What is the status of the FIR and investigation? And
why not a single
Mulus,
assailant has been arrested till date? There's an eyewitness, no dispute?
Yes, Mulus.
Why not a single of the assailants has been arrested till date?
I'll take instructions on that.
Then keep your
Because the impugned order, High Court has made some arrangements. Your Lordships have seen the impugned order.
What arrangements? Shifting him to another prison?
No, that is as far as,
not an arrangement which is
that is
required.
because as far as he apprehended that there would be serious concerns about his custody or he being
the High Court
the police trying to hit him.
that about his safety inside the jail.
Yes,
Because
that's right, Mulus.
There is issues of his safety inside the jail also.
That's right, Mulus. Would Mulus kindly see, yes, Mulus, page 3, Mulus, para 5, how the High Court has dealt with this. Investigation is also transferred, Mulus. Para 5.
To the original FIR, how does the High Court deal with that? Of homicide?
May I just place Mulus para 5 onwards, Mulus? The picture will be slightly clear, Mulus. Having considered the manner in which the police proceeded in the case, this court finds that it is the case in which definitely investigation should be monitored by the Superintendent of Police Guna. The court would also like to observe that it is a case where accountability of the senior police officer may also be required to be fixed administratively. This court is of the view that the investigation conducted by the CID should be monitored by the SP Guna, and the SP Guna shall submit status report to this court. So, Mulus, status reports have been called.
What is said about this in the counter? What is the status of investigation as on date?
Mulus, the present, Mulus, on that, Mulus, there is nothing.
Apparently.
Mulus, because only bail is being.
Reasons are writ large.
Mulus, in the present petition, Mulus, only the bail is being pressed, Mulus.
1 minute. Read
The
paragraph
present
3 of the
petition.
High Court order.
SLP is before us, Mr. Joshi.
Yes, Mulus,
They may be pressing for whatever they are. The facts are there.
And we are not going to close our eyes to all this.
No, Mulus.
You read paragraph 3 of the order.
Yes, Mulus. Para 3.
What has the magisterial inquiry found and what have you done after that?
So-and-so is brought to the notice of this court that the report of the magisterial inquiry and has argued that in the said inquiry, Inspector so-and-so, Constable so-and-so have been directed to be made accused in relation to the custodial death of their party, and accordingly FIR has been registered against them.
Now there is a named FIR on the basis of an inquiry conducted by the magistrate.
Yes.
This is stand of
This
the
is
state
stand of
government.
the state government. And still nothing has been done. According
Mulus,
to
I'll take that's according to her, Mulus. I'll take instructions whether action has been taken or not, Mulus.
All right, Friday.
Friday, I'll take instruction.
Okay, very serious allegations have been made.
Mulus, without saying
No,
anything,
just one
Mulus,
line.
I'll come. I'm here, Mulus. On
Well,
Friday,
just
Mulus,
one
everything will be
line.
indicated, Mulus.
Very serious allegations have been made against the police administration of the district, that despite there being a named FIR under section 302 based upon an inquiry report by the magistrate, although FIR was registered but no further action has been taken on the same and no arrests have been made. Also, Shri Nachiketa Joshi, learned senior counsel appearing for the state of
Madhya Pradesh,
seeks time to obtain instructions in the matter. नहीं, उसके बाद लिखिएगा, we were inclined to summon the Director General of Police and the Home Secretary of the state when Mr. Joshi made a request that 2 days' time may be granted to obtain instructions in the matter, and thereafter the court may consider calling the officers to stop. Yes, this matter again on Friday. Mr. Joshi to obtain instructions in the matter. Next.
Please. Oblige.
May I please? As per my lords, in section, I filed my affidavit along with the pay slip, my lords. And I also filed an application under 142 to grant divorce on the ground that the marriage has been irretrievably broken. The marriage happened in the year 2009, my lords. The date of separation is in the month of July 2010 itself. We've been fighting.
24. 26.
26, my lords. Item 26. I'm so sorry, 26, my lords.
One. A. Ranjit Kumar.
Please, my lords. I appear for the petition, my lords. So on the last occasion, my lords directed me to file an affidavit along with the pay slip and income statement, my lords. I have filed the same. The marriage happened in the year 2009, my lords. From the month of July 2010, they're being separate. I filed a cruelty petition before the family court. It was decreed, reversed by the High Court in civil miscellaneous application. And thereafter, my lords, I filed an SLP notice issued for mediation. Now the marriage has been irretrievably broken. I have also filed an application under 142, my lords, requesting my lords to invoke Article 146, my lords. I'm willing.
So your total gross salary is 2,20,000.
Please, my lords.
And after deductions of 70,000, you take away, home take away is 149.
149, my lords.
1.5.
And I have a wife, two sons from the second marriage. Second marriage was done after the 139 days from the date of decree of divorce, my lords. Because my instruction is that he's paying 40,000 for.
Respondent is also working?
She was working, but her affidavit says she is not working as of now. She is a postgraduate, a chemical engineer, and I'm told that she has some assets. I'll leave it to your lordship. I'm ready to pay some lump sum amount.
What?
Because my instruction is that 25 lakhs, my lords. Okay. My lords may give me any reasonable amount.
I'll children out of the.
For one son.
He's with the mother.
The child is with the mother, my lords. They have filed recently on 2020 in the year. They filed.
How old is the child?
The first son is 15 years old, my lords.
15 years.
Yes, my lord. Lord, what they have filed pay 7, my lord. Only a pay slip, lord. Not, that is not in consonance with your lordship's order, my lord.
All right. We have seen that.
2004 till 2000, my lord, 15.
Actually, it was our mistake. We did not mention Neha versus Rajneesh. What is that?
Yes, my lord. But that they should have done.
They have taken advantage of that and
Yes,
they have filed only the pay slip.
Absolutely, my lord.
That is mistake committed by us.
I won't say, my lord.
They did not file a proper affidavit of assets and income.
2004.
This is not required. You know that. Oh, you are not aware of. They are.
Only one property he purchased in his second wife's name. All other properties are in his parents' name. As in section.
You mentioned this in your affidavit?
No, my lords.
No. Why have you not mentioned this?
Lord, 2004 till 2015, my lord, he was in USA, my lord, earning $12,000 per month, my lord. My lord, I have stated, my lord, I have given his biodata also, my lord, wherein he has mentioned, my lord, if my lord sees my reply, page 19, my lord, his own biodata, my lord, in 2009, he was stated to be earning, my lord, $6,000 at that time, my lord. 2012, he got green card, my lord. If my lord sees page 19 of my counter affidavit, his own biodata, my lord, salary $6,000 per month. Thereafter, property, my lord, 2 houses in Vellore, 2 housing plots, 1 shopping complex, owning a car. Now, thereafter, my lord, page 20, 2004, he is earning, my lord, in USA, came for the purpose of this case only, my lord. He will go back again, my lord. So what that has been given a complete eyewash, my lord.
Totally eyewash.
Yes, my lord. Page 20. Yes, my lord.
2013 he came. 2013 he came back, my lords. Green card expired. He is now working in a company in Hyderabad, my lords.
The assets have not evaporated. What he accumulated.
These two properties are family ancestor property, my lord. I'll file an affidavit to that effect, my lord.
And para 46 High Court's order, my lord, merely he has married second wife, my lord, without filing a caveat.
That is not a fait accompli, my lord. I am, my lord, on my miseries, my lord, he has, my lord, married during, my lord, that time, within my lord, 101 days, my lord.
I'm at your
And
lordship's hand, my
he
lords.
did not file even caveat, my
instruct
lord.
my client, whatever it's falling for my lords, I'll instruct my client, my lords. I'll file
And
an
my lord
affidavit.
said he should not.
Any amount
only
if my
for the
lords is
purpose of
indicating, I'm ready to pay.
Caveat is his discretion. Why should he?
That I understand, my lord. Only within, my lord, few days, my lord, he got married, my lord, and I have been told, my lord, that he was living with her, my lord, and in May 2017 he was having child also, my lord.
Because you are not vigilant, that's why. So he was watching.
What
He had briefed his counsel to count the dates.
So what he submit, what I want to say, my lord, though he filed divorce petition, my lord, but he was living with his second wife, my lord, and
Okay.
so
Now
this is on my miseries, my lord. I am taking care of my.
So you going to that path now. So only a issue of alimony which has to be.
That I understand, my lord. 2010 till date, my lord. I am taking care of my child, my lord.
Yes. Maintenance.
No maintenance, nothing, my lord. And he is earning, my lord, in dollars, my lord.
All right, all right, all right. So,
And baseless allegations, my lord. Adultery with my father. Such type of remarks, my lord. This person does not.
With his father.
He is making allegations, my lord, that I am having adultery with my father. Now he says, my lord, that I will go to USA and stay with one Prabhakaran. What this is all, my lord, there, my lord. That I want to go to USA and shift with Prabhakaran, my lord. And, my lord, time and again, my lord, I tried my best to settle with him, thinking of my child, my lord.
Because whenever we try to pay maintenance, they rejected it, my lord. They've never accepted any money from
all
us.
right, 1.5 crores you pay, we will give you a decree of divorce.
I have to seek instructions because one point he.
Take a call your client and tell us in 5 minutes.
Please,
Or else your marriage becomes illegal.
I understand.
Yes.
Yes.
Yes, but
That would have
1.5.
its own consequences in your green card.
He's not in USA, he's in Hyderabad only, na?
He's in Hyderabad. Green card is expired, my lords. I can file an affidavit. He's not going back, my lords.
Get it revived.
1.5 crores will be very, very difficult as per my lords. Some.
Find out.
I'll get.
You know, let keep your wife and son with yourself.
We dismiss it, but pray.
I totally understand, my lords. I'm at your lordship, my lords, but 1.5 lakhs is going to be very difficult. I'll take instruction, my lords. Lordship.
Not lakhs.
Oh, sorry, my lord. 1.5 crores. I'm so sorry, my lords. Lordship, may tomorrow, my lords, or Friday, my lords?
Friday?
Friday, my lords.
All right.
I'm grateful.
Likhiye. During the course of arguments, a figure of rupees 1.5 crore as one-time permanent alimony has cropped up. Full stop. Counsel for the petitioner husband wants time to obtain instructions. List again on Friday.
In the meanwhile, I'll file an affidavit regarding green card and the property also, my lords.
Come back ready with that. There is no need of any affidavit.
I understand. My lords, but I have to indicate 1.5 is very, very difficult for him.
Sell off some of your property.
It's not his property. It's his uncle's property. There are siblings also. Not
Father's
his
property.
Father's mother's property.
Father will help you, sir.
Father's property, my lords.
It's yours.
Ancestral property.
Anyway, you
I'll
take
take
come
instruction.
back. You're not interested in
I'm grateful.
further argument.
I'm grateful.
How do you get it?
Public.
I'm praying for a Passover, my lord. So Guru Krishna Kumar is leading me.
Passover, it may not come, then you might as well take a day. Who appears for the petitioner?
On Mr. Kapoor, my lord.
He's also not here.
I'm sorry. I'm for the petitioner.
Then why are you standing on the... So Naveen Prakash, you...
Seeking Passover,
All
therefore
right.
don't pay attention.
Passover. You are for responding?
Yes, responding.
Next.
Your Lordship, item 28 was mentioned before lunch.